that last 10% is the most difficult to service in the best of times. So post-hurricane, it is particularly challenging. That last 10% uses approximately 40% of your pumps because of how scattered our development has been as a nation post-independence. So, yes. So, though we refer to the national water policy and all the variants of it that have been there from the 60s, a large chunk of it really deals with social water because the economic case for this would be a challenge. And when you have an event like Hurricane Beryl, that's laid bare to see. Now, we are working very closely, firstly, President, to acknowledge the staff members of NWC and JPS. They are coordinating at the national management level, and at the parish levels, there are meetings every single day to focus on the priority pumps. The first priority has been met, which is that the pumps serving our hospitals and our infirmaries have been energized at this stage. Doesn't mean they're not damaged to lines and supporting infrastructure in the area, but we're able to supply our hospitals and infirmaries. I want to make the point also, though, because it was in the news, that the system that supplies Mandeville Hospital is fully operational now, Mr. President, and that hospital is getting water from the line and no longer requires trucking. But all our hospitals are now back up, and our infirmaries are back up as well. Beyond that, you look at the systems that are either most impacted because of damage or the ones where you can get water to as many people as is possible first. And there's a bit of a mix. The two major systems, or the two systems that are classified as major systems, which are still out of JPS Energy, is actually the Roaring River and the Bogue systems in St. Anne. Because, you know, fact is often stranger than fiction. St. Anne was the third worst impacted in terms of impact to its energy grid in the country. So 79% of the grid was damaged in that area, which impacts two of your major systems, which impact water supply from mid-St. Mary to a section of Trelawney. So, you know, the systems are integrated. But we are working around the clock with JPS to restore lines where there is damage, to replace transformers where they have blown, and we've taken it a step further. We are working very hard with local and international partners, through Minister Johnson Smith and Minister Dana Dixon, to get as much support as we can for temporary reprieve and longer-term resilience by way of alternate power supply. We have been using a system of alternating generators to ensure that communities that are have been out for several weeks can get 2 to 3 days to refill storage while they move to another community that has a similar type issue. But the long-term fix will require a significant investment into generators to support our over 700 pumps between your water and your sanitation systems to build in that sort of resilience. The first 50 we will target coming out of this storm, and we are in the process of procuring those, will cost approximately $750 million. These are not your household generators, regardless of the size pump that you drive on the side of the road and see they use triple phase power, and invariably they suck a lot of energy, which is why NWC is the largest customer of JPS. But we are working on the short term, we're working on the long term, Mr. President, and of course we are using every available truck in Jamaica to give citizens as much support as we can in the communities that have been out for the longest period. The challenge you have with truck availability at this stage is that those private truckers who own their own resource are able to get paid upfront in cash by many citizens who are out of that space, so they're not as available to either the parish councils or to NWC in times of crisis. This is why we have prioritized the purchase of an additional 8 trucks, which was in procurement prior to the storm and should be here soon. This is why we'll continue to build out our resilience measures. But just to assure citizens that we are working around the clock, we understand the plight and the impact this storm is having on the way of life. The basic necessity of water is critical to the functioning of our society, and We assure citizens that we're doing everything that is possible. We're working with every international development partner, every member of the private sector, every NGO that is willing to assist. And by God's will, we will be over this very soon. Thank you.
Thank you, Senator Samuda. Senator Fraser-Binns.
Thank you, Mr. President. And I want to join with yourself and my colleague Samuda to just express our heartfelt sympathies to the persons impacted by Hurricane Beryl. Mr. President, when I heard about the hurricane, at first I was like, okay, I'm going to watch it like I watch every hurricane to see if it's coming to Jamaica. And I think it was the day before the hurricane. I mean, I did my usual stocking up of water and prepare the house. And the day before the hurricane, there was a meeting of the parliamentarians. And coming out of that meeting, I remember calling my husband. I said, this hurricane is coming. And he said, why? And I said, because there was a meeting of parliamentarians, and we are sure it is coming based on everything that was discussed. And that caused me to take a second look at my own preparedness. And those close to me, I reached out and said, make sure you prepare yourselves. And I say that, Mr. President, because I think for many of us, myself included, it was the first that we would, at least as grown-ups, can recall having anything like this in Jamaica. We've had Category 2, we've had things that missed Jamaica, we've had a lot of rainfall, but I don't think we've experienced, certainly those in my age group and younger, Senator Sinclair, have experienced anything like this. And but Mr. President, I use that example because there are so many lessons that can be learned from Beryl. Because a lot of us really, I don't think we take hurricane preparedness seriously. And one of the things that I think must come out of this as a country is how all of us, from the government to the individual in the homes, take hurricane preparedness seriously. The second thing as well is the need for greater education so persons understand what preparedness is about. And then, Minister Samuda, I thank you for a response, and I thank you for what work you've been doing, and we have been speaking before and throughout Beryl. But one of the things that we now know, if we ever had any doubt, is that preparedness trumps response. And I say that because when I visited St. Elizabeth last week, what I saw was a slow pace of response by the government. Now, I am not saying that there hasn't been any response, but Minister Samuda, every household we went to, they tell us that the government, the ministry representatives have come and they're doing assessment. And they say to us, and I was sharing this with my colleagues, that we can manage without the light, but we need water. And a number of them said to me, see my black tank here? It's not like we're waiting, we have the black tank, but either it was blown off or there were holes in them because of the flying zinc and they had no water. I understand that is a consequence of hurricane, but I think that more could have been done. And I don't think it's very difficult. So we have no electricity. We could have perhaps truck water. I know the condition of the road because I saw it myself. We could have carried bottled water. And I'm just imploring the state agencies, the government, to do a little bit more with the human response side of it. I think you've been doing some with the infrastructure, but there needs to be more with the human side. The other thing as well is that as a country, we have to make sure that we build resilient infrastructure. I think that the time has come for our utility companies to consider whether we must go underground instead of aerial. And we understand that there may be an argument about what happens in earthquake. But the fact is that the studies have shown that where there's underground infrastructure, the response time is much shorter. And I think that is something that as a country, we need to look at. Mr. President, I also believe that part of the preparation has to be with assessing what we have before and putting things in place. And I speak specifically about just basic things. When I say basic things, but again, it doesn't take a rocket science, like just having generators available. I know, for example, one of the concerns coming out of parishes where there's no water is that there's no electricity. But we have to ensure that if another hurricane or another natural disaster of this kind comes, that we do not wait on JPS to be up before we can give water. It means, therefore, that we have to be more proactive in how we plan for natural disaster response. And I am not taking away anything from ODPEM because I believe that they are doing the best they can with the resources available and the National Disaster Council. But I think that there are so many lessons that we can learn as a country to ensure that our preparation and our response in the next event is much faster and more proactive. And the final thing I want to say is I know that efforts have been made by successive governments in terms of giving black tanks to persons, and that is something that I support because of the need to have water and access to water. But another lesson that we have learned from the hurricane is perhaps we need to, as we continue to champion Minister Samuda rainwater harvesting, is that we may need to have a combination of underground cistern and black tanks, because that also gives some amount of independence to persons in times like these when you have Category 5 hurricanes and the black tanks are blown off or roofs are impacted. And as we talk about black tank, I think that as a country, we are also forced to consider how we build a climate resilient country. I know that work has been done in terms of preparing us financially for our response, but I think more attention must be made on how we prepare ourselves before the response. And I spoke earlier about building resilient infrastructure. This is something that we can do. This is something that we must do. And part of that is going to be, what kind of houses are we building? Are we now going to have to consider a shift away from zinc roofs? And if we're going to do that, then we must consider the cost associated and how can the state assist in reducing cost. I know that these are big conversations that must be had, but I think that what Beryl has done is that it has forced us to go back to the drawing board, to tick off the things that are working, to assess those that are not working and see what are the options that are available. And with that, Mr. President, I want to thank all our first responders. There are so many of them who, during the hurricane, had little children but had to leave them because they needed to be at work. Our doctors had to be at the hospitals. Our firefighters, our policemen and women, they had to be at work. And we really just want to thank them for their commitment to national duty. And, we believe that, as I said earlier, there are so many lessons that we can learn from this hurricane, because there will be more. There will be more, because it is our new reality because of climate change. So thank you, Mr. President.
Thank you. Thank you, Minister. I'm not really opening a debate, Mr.
Mr. President, I didn't want to stop the flow of the statement, but the cost for generators for the water network that exists in Jamaica is, a point of information, is $78 million US. The In Jamaican dollars, it would be about $11.5 billion. Why I said clarification, because the point was made that perhaps enough wasn't done before, but the total capital spend on water between 2012 and 2015 was about $1 billion to $1.5 billion a year. There would be no ability for that to happen. And what was inherited in 2016 was a bankrupt NWC. We are the ones that started buying generators last year. And I think it's important that the country knows that they did start buying them, but the awesome cost should not be taken as a lack of preparation. And I think that has to be said for the answer.
Thank you very much, Senator. Members, yesterday I had the pleasure of attending the swearing-in ceremony of the Honorable Mrs. Justice Marva MacDonald Bishop as a new president of the Court of Appeal. Mrs. Justice MacDonald Bishop has the distinction of being the first woman to serve as president of the Jamaica Appellate Court. Mrs. Justice MacDonald Bishop has had a stellar career since being called to the bar in 1996. And in fact, a number of our colleagues have also, from that year, have distinguished themselves in the judiciary and at the private bar. Her experience in the judicial field has been extensive, and she served as a clerk of courts at Halfway Tree, which is where I first met her, as Crown Counsel at the Office of the Director of Public Prosecutions, which I interacted with her as magistrate, where I appeared before her, before being appointed to the Supreme Court as a puisne judge. Mr. Justice Bishop was appointed a judge of the Court of Appeal in 2014 and has served the court with distinction since then. Mrs. Justice MacDonald Bishop is an erudite justice, and her elevation to the highest post of the appellate court is not only momentous, and a momentous achievement for herself personally, but a boon to the Court of Appeal. I once again offer Mrs. Justice MacDonald Bishop our sincere congratulations as she heads one of the essential arms of the administration of justice in this country. Thank you. The one thing I forgot to say, so that nobody else says it and get a round of applause, is that she's from St. Mary. Thank you. Minister.
Thank you, Mr. President. I think it's safe to presume that it's going to be repeated, notwithstanding, and there will be more applause. But as it's so well merited, we'll excuse the St. Mary people. I just wanted to add a few words, Mr. President, of commendation and indeed celebration. I do believe that every time a glass ceiling is shattered, that it should be recognized, it should be celebrated. And even where it is that justice is exercised for all, it is dispensed to all, and one does not, I don't think there's ever been an observation that women judges dispense justice any differently from male judges. But the issue for me is one of representation and one of recognition of the removal of barriers, and the fact that in Jamaica, in fact, there are no legal barriers for women to rise to the highest levels of service where they are able, where they work for it, and where they display the characteristics such as Justice MacDonald Bishop has. Her erudition, her clarity, and plain speaking even, when she is ready, her capacity, her mettle, for which she is well reputed, are things to be celebrated and welcomed. We have had our first woman serving as Chief Justice. We have had our first woman Attorney General. And I always say, we work for the time when we don't have to celebrate firsts anymore. But until then, we continue to celebrate them, for they are indeed great achievements. So I wanted to recognize this in particular. You spoke to her career, so there's no need for me to repeat the areas in which she has served. But I do wish to say that I think it is, again, another opportunity for young girls to look on and say, I can, I believe, I am, I will be, and for them to manifest that in the hard work that they put into building the career that they wish. So I really want to commend her, to wish her every success in her tenure, as her success will, of course, be the success of the Jamaican justice system, which, of course, means operates rather to the benefit of the Jamaican people. So I thank you, Mr. President, for raising this matter, and again ask that the commendation to our new President of the Court of Appeal, Justice Marva McDonald-McIntosh, be recognized in this context. Thank you.
Thank you, Minister. Senator Scott Motley, I recognize you from a seat other than your own.
Thank you for sparing me the need to ask, President. Even as I rise to join in the congratulations to the first female president of the Court of Appeal, I want to acknowledge the service which Justice Brooks has given. He has not only served us with distinction, but with humility. One of the most affable and approachable presidents that we have had. Of course, you'll forgive me because we go way back. He's older than I am, not by many years, but we had a little stint at the Attorney General's department together. And so there's still some sort of, relationship which we share. But never at any time has that interfered or with how the level of professionalism which has been demonstrated both from the bench and from the bar. And that's one of the things that I say about the Caribbean Court of Justice when people say, oh, but you know each other. We all know each other. We just have different relationships. I am so pleased to see that Justice Marva McDonald-Bishop has been elevated to this position. As leader of government business has said, we have to celebrate women when they actually do succeed in this way. And we only wish that we don't need to say the first, because it will be quite commonplace. Most of the judges on the court now, parish court, Supreme Court, and even Court of Appeal are women. But there's still a tendency that when you're searching for someone to occupy the highest position, you automatically, I'm not quite sure why, but you turn almost instinctively to select a man. And so I really believe that today, women who serve have every reason to celebrate that acknowledgement. Sometimes women who serve are simply seen as servants to do the job, but never to hold the top job. Marva McDonald-Bishop has impressed the legal profession with her erudition, with her judgments, which some say are very lengthy, but which go into details so that you can appreciate the kind of judicial reasoning that led her to making that decision. As you have said, President, so well, she has had a stellar career, and it is nice to see that she has been rewarded for the contribution which she has made to the judiciary. There are not many people who might know that she also has a beautiful singing voice. So she brings many things to this position. But I am sure that what she will do is uphold the integrity of the judiciary and demonstrate that judicial reasonings are based on the law and not on any bias. And I look forward to seeing her perform in that capacity, if it pleases you, Mr. President.
Thank you. Is it only one time? That's very uncharitable. Senator, thank you, Senator Scott Martin, and I echo the sentiments concerning former President Brooks. Like McDonald Bishop, he's someone who I've had the pleasure of working with over the many years, and I agree with everything that you have said, not only in relation to his legal capacity, but the personally humble manner in which he approaches the work. So that I would ask the clerk to write to both former President Brooks and new President McDonald Bishop, indicating in relation to Mr. Brooks the gratitude expressed by the Senate for his service to the country through the judicial system, and to the new President, wishing her the best and indicating that to her that we expect nothing but the highest level of service, and congratulate both of them. Thank you very much. Announcements? I'm sorry, statements by ministers. Announcements?
Laid on the table of the Senate are the following. Annual reports of the Protected Disclosures Act 2011 for the calendar years January 1, 2022 to December 31, 2022, and January 1, 2023 to December 31, 2023. Annual reports of the Forestry Department for the financial years 2012, 2013, and 2013-2014, along with their related ministry papers numbered 36 and 37 of 2024, respectively. Annual reports of the Integrity Commission for the financial year 2023-2024. The Planning Institute of Jamaica's Economic and Social Survey Jamaica 2023. Auditor General's Department certified appropriation accounts under Head 06000 for the Office of the Services Commission for the year 2017-2018, Head 15,000 recurrent for the Office of the Prime Minister for the year 2019-2020, and Head 256 for the Tax Administration Jamaica for the year 2022-2023. The Capital Development Fund Withdrawal Number 1 Order 2024 and its resolution under the Bauxite Production Levy Act. And finally, the National Housing Trust Housing Benefits Special Selection for Shrewsbury Phase 2 Housing Development Order 2024 and the Savannah Park Housing Development Order of 2024 under the National Housing Trust Act. Thank you, Mr. President.
Thank you, Madam Clerk. You know, members, one of the reasons why annual reports and such documents are tabled in the Senate, it's really twofold. First of all, to bring it to the attention of the public, to make the document available through the mechanisms of the Parliament. But equally important is that the document becomes a part of the record of the Parliament. And that record will be inevitably researched at some time in the future, and reference will be made to the various annual reports. Those annual reports will be available, of course, through the individual organization that sends them here, but equally, because they are placed on the record of the Parliament, I think they do carry a bit more authority, if you will. And I'm going to just make an observation which may or may not be considered to be one inviting comment, but it's really just to make an observation in relation to the Integrity Commission Annual Report of 2023-24, because as I said, it is placed on the record of Parliament, and therefore I have the authority to comment on it. In his chairman's remarks on page 4, the Honorable Mr. Justice Panton, OJCD, makes the following observation, and I quote, "During September 2023, a serious criminal act was committed in the vicinity of the office of the Commission. One of its directors were shot and robbed." And I think all of us would remember, this is not him saying this, I think all of us would remember the absolute alarm that was visited on us when we heard about this incident. Mr. Justice Panton continues, "The crime remains unsolved." And he goes on, "I imagine that investigations are taking place. However, neither the director nor the commission has received any update on the incident. That is to say, neither the director who was shot and robbed nor the commission has received any update on the incident. The police ought to be very concerned that this happened in New Kingston Business District, where there is no zinc fence, no bushes, and very few side roads. Yet the perpetrator was able to disappear without a trace in the clear morning light." End of quote. I must tell you that when I read this, I was, of course, quite disturbed about what is contained here. And the police subsequently held a press conference in which the Commissioner of Police and Deputy Commissioner of Police indicated that the individual who was shot and robbed had refused to give the police a statement or to cooperate with the investigators. The clear inference from what Mr. Justice Panton says is that the police were negligent in their duty. What the police are saying, in fact, is that the director, the senior director, failed to cooperate with the police in even giving them a statement. I suspect that Mr. Justice Panton, no, not. So it is clear to me, or I suspect, that Mr. Justice Panton could not have been aware of the present situation when he wrote this paragraph which suggested that the police were negligent in their duties. I expect that the Integrity Commission will therefore provide for the record of the Parliament an addendum as it relates to this particular incident, because the comment by Mr. Justice Panton casts a shadow on the investigation by the police officers. Bills brought from the Honourable House of Representatives.
Do I understand you're going to write to the chairman indicating what you have done so that he may also respond having regards for what you have said on the record of this Parliament? Because he's not here to defend himself.
Thank you, Senator Brown.
So, no,
I'm not really getting into any discussion.
No,
about
but
it,
you have entered into the reference on that matter, and to appear president, that sides, you have drawn a conclusion without hearing from all sides. And I'm saying, are you going to write a letter to the chairman saying, in light of what has happened, is he going to provide an addendum? So it gives him an opportunity to comment on what you have said, and we believe that fairness requires no less.
Senator Brown, I've noticed I note what you have just said. Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives. To the Honourable Senate, I have the honour to advise the Honourable Senate on the following bills. On the 9th day of July 2024, a bill entitled An Act to Amend the Income Tax Act was passed in the House of Representatives. On the 16th day of July 2024, a bill entitled An Act to Amend the Road Traffic Reprieve and Nullification of Prescribed Notices Act was passed in the House of Representatives, signed Juliet Onis, MP, Speaker of the House of Representatives.
Minister Dixon.
Mr. President, I signify my willingness to take charge of the bill, and that's the one entitled the Amendment to the Income Tax Act.
Thank you, Minister.
I too signify my willingness to take charge of the bill, and that is an act to amend the Road Traffic Reprieve and Nullification of Prescribed Notices Act.
Thank you very much.
A bill shortly entitled the Income Tax Amendment Act 2024 read a first time. A bill shortly entitled the Road Traffic Reprieve and Nullification of Prescribed Notices Amendment Act 2024 read a first time.
Senator Dixon.
Mr. President,
Minister Dixon, I'm sorry.
Mr. President, I beg to give notice of second reading of the bill.
Thank you, Minister Dixon. Minister Samuda.
Mr. President, I too wish to give notice of second reading of the other bill.
Thank you, Minister. Petitions, papers, reports from committees, notices of motions given orally. Minister Johnson-Smith.
President, I beg to give notice that at the next meeting of the Senate, I will move the following motion. Be it resolved that the National Housing Trust Housing Benefits Special Selection Savannah Park Housing Development Order 2024 under the National Housing Trust Act, which was laid on the table of the House on the 19th day of July 2024, be referred to the Regulations Committee of the Senate for consideration and report. And Mr. President, I further beg to give notice that at a later stage today I will move for the suspension of the standing orders to enable me to take this motion. I also, Mr. President, beg to give notice that at the next meeting of the Senate I will move the following motion. Be it resolved that the National Housing Trust Housing Benefits Special Selection Shrewsbury Phase 2 Housing Development Order 2024 under the National Housing Trust Act, which was laid on the table of the Senate on the 19th day of July 2024, be referred to the Regulations Committee of the Senate for consideration and report. Mr. President, I further beg to give notice that at a later stage today I'll move for the suspension of the standing orders to enable me to take this motion.
Thank you very much, Minister. Questions and answers to questions? Minister Dixon.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motion.
Oh, I'm sorry. Yes, that I recommit notices of motions. Those in favor? Aye. Thank you, Senator Dixon. Minister Dixon, I'm sorry.
All right. Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motion. The Data Protection Act, the Data Protection Disposal of Personal Data Regulations 2024 Resolution. Whereas by virtue of Section 74(1) of the Data Protection Act, hereinafter referred to as the Act, the Minister may make regulations for giving effect to the provisions of the Act. And whereas Section 28(1)(b) of the Act provides that the disposal of personal data by data controllers shall be in accordance with regulations made under Section 74 of the Act. And whereas Section 74(3)(g) of the Act provides that regulations mentioned in Section 28 of the Act prescribing methods for disposal of personal data shall be subject to affirmative regulation. And whereas on the 4th day of March 2024, the Minister made the Data Protection Disposal of Personal Data Regulations 2024. Now therefore be it resolved by this Honourable House as follows. 1. This resolution may be cited as the Data Protection Disposal of Personal Data Regulations 2024 resolution. And 2. The Data Protection Disposal of Personal Data Regulations 2024 is hereby affirmed. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Thank you very much, Minister. Questions and answers to questions? Senator Brown.
Yes, Chairman. The question notice paper has a question number 2. that is due for answer today. I've been kindly informed by the Minister that it's not ready, and I understand, because the nature of these questions will require some amount of research and hopefully with focused government action. So I hope that soon we can get the answer, knowing that it's not going to come before we take the break.
Yes, Senate Minister.
Thank you.
Dixon.
Thank you, Mr. President. And just to assure Senator Brown that the work is being done, we have already written to all of the ministries, because your questions relate to every single ministry in the government, and we have written to them and they have started to respond. And so I do expect that we will be able to give you a very fulsome response once all of the information comes in.
Thank you very much, Senator Dixon. May I just, while on questions and answers to questions, Senator Fraser-Binns had sent me some questions which I had approved but had failed to send them on to the clerk. So, Senator Fraser-Binns, I'll pass them to the clerk for the next occasion, so I apologize. Motions that may be made at commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate for public business. Minister.
Thank you, Mr. President. Mr. President, first item of business is to move for suspension of the standing orders to enable me to take the two motions, notice of which I gave earlier, and those are in respect of the National Housing Trust Development Orders for their submission, or rather reference to Regulations Committee of the Senate for consideration and report. I ask that that the standing orders be suspended.
Members would have heard the question. Those in favor? Against?
Mr. President, I now ask that the motions be approved.
The question is that the motions put forward by the minister be approved. Those in favor? Against?
Thank you, Mr. President. Mr. President, it is intended today to proceed with two items of business. One will be taking the Data Protection Act regulations, which had been tabled some time ago, although notice was given this morning, and to take the act to amend Section 61 of the Constitution of Jamaica to provide for new words of enactment. It's intended to proceed with the latter first and then to take the notice of motion. So, Mr. President, with your leave.
Thank you, Minister. Go ahead, please.
Thank you. Mr. President, since 1962, Jamaica's independence constitution has been the supreme body of guidelines concerning duties, rights, and obligations of citizens and government. And as a constitutional monarchy, although the people of Jamaica express and exercise their will through an elected and autonomous parliament, laws passed within our parliament are still enacted by the words, "The Queen's or the King's most excellent majesty." And this is because the Constitution sets out how bills are enacted. It does so under Section 61, and this bill seeks to amend those words of enactment by providing new words, prescribing new words, which reflect the autonomy of Parliament. Mr. President, throughout the years, Jamaicans from all walks of life have expressed the view that full independence, true political independence, requires decisive constitutional reform to shed colonial and monarchical vestiges, to move towards a republic, and to properly embody the identity, aspirations, and spirit of the Jamaican people. This perspective has broadened as more people have become more aware and more engaged on these issues. Thanks to the important constitutional reform work underway, many more Jamaicans are becoming more acquainted and reacquainted for some with the historical circumstances regarding the origin of our current constitution and the circumstances of our independence. One point of interest that I found, Mr. President, coming out of the CRC consultations, is that many Jamaicans find it very interesting that our current constitution is contained in a schedule to a British imperial instrument, the Jamaica Constitution Order in Council 1962, made at the court at Buckingham Palace in England on the 23rd of July 1962 by virtue of Section 5, subsection 1 of the West Indies Act 1962. So our constitution is actually a schedule to a British document. And this point was actually noted by the CRC, Mr. President, to be one which is unacceptable. And it's one of the areas in which there is this very sort of burning recognition that some things just need to move forward. And the Jamaicanization of our Constitution is one of these things. I want to make note of the fact that this term, the Jamaicanization of the Constitution, is credited to Mr. Lloyd Barnett, whose reputation undoubtedly is very well known to every member of the Senate and indeed the listening public, as his work in law generally and in constitutional law specifically is extremely well known and respected. But it is a term which has gained, is gaining greater popularity, the Jamaicanization of our Constitution. So, Mr. President, Jamaicans have been yearning for full independence for decades, and this government is working to deliver on our promise to deliver this. Working not only towards economic independence, but what may be viewed as full political independence through our road to republic status. So to guide this process to a decisive conclusion, we have established a Ministry of Legal and Constitutional Affairs. And furthermore, on March the 1st, 2023, a Constitutional Reform Committee was established to provide expert guidance and a collaborative consultative mechanism to the government and the people of Jamaica during a complex phased reform process. Mr. President, the government is committed to delivering a modern constitution which reflects Jamaica's cultural heritage, our governance and development aspirations, and which embodies the will of the people of Jamaica. Mr. President, the Minister of Constitutional and Legal Affairs has shared views elsewhere, and the ministry itself and the CRC has thoughtfully and intentionally and very carefully set out phases through which reform will progress. In phase one, the government's position is that the abolition of the monarchical form of government will be abolished, the King of England removed as our head of state, and the Republic of Jamaica established. Simultaneously, the Constitution will be Jamaicanized by repealing and replacing the present imperial instrument, which I spoke to earlier, with a Jamaican instrument made by our Parliament and approved by the people of Jamaica in Jamaica. Mr. President, the bill before us today is concerned with the first step in this process, and it's concerned fundamentally with the recognition of the dignity and autonomy of the Parliament and the people of Jamaica. It is equally concerned with fully expressing that power vested in public officials by the people is exercised for them and on their behalf. Over the years, there have been a few amendments in this regard. Amendments have been made to laws that are subordinate to the Constitution. For example, in 2002, the Oaths Amendment Act was passed, which inserted references to Jamaica and to the people of Jamaica instead of the British monarch in the oath, the official oath, which we all take. Mr. President, as a result, the oath of allegiance now demands faithfulness and bearing true allegiance to Jamaica. This was amended in 2002. Upholding and defending the Constitution and the laws of Jamaica, and conscientiously and impartially discharging responsibilities to the people of Jamaica. The official oath now demands takers, therefore, to well and truly serve the people of Jamaica in office. So, Mr. President, given that public officials now already swear to act in our interests, so in the interests of the people of Jamaica, it is only appropriate that the very laws that govern us be approved by us, the people of Jamaica, and indeed our Parliament, this Parliament. And that effect can only be had through constitutional amendment. It's important to note that the words of the enactment of a bill, of a bill, indicate the source of authority of that bill. So Section 61 of the Constitution of Jamaica currently prescribes the words of enactment that must accompany every bill tabled in Parliament, regardless of the nature of the bill, and they begin, "Be it enacted by the Queen's Most Excellent Majesty." Members will agree that after more than 6 decades of political independence, this is unacceptable. And indeed, the CRC also found that it was not acceptable that these words continue. The government firmly believes that it is important to express the supreme authority of Parliament of Jamaica in all legislative matters. And very importantly, Mr. President, the proposed amendment to Section 61 of the Constitution is an important step on our road to becoming a republic. Having replaced the words of enactment for all bills of Parliament, when the bill to transition Jamaica from a constitutional monarchy to a republic is passed, it will state that the enactment is made by the Parliament of Jamaica. Mr. President, this idea of reformulating the existing words of enactment was in fact first considered by the 1991 Constitutional Reform Commission of Jamaica in its 1993 report. And it was recommended at that time that the words, "the people and Parliament of Jamaica," replace the existing words of enactment. The 2023 CRC, the body recently established, considered these recommendations, and in their report recommended that where a bill requires the approval of the electorate, the words, that is, where it requires a referendum, then the words of the enactment should make reference to the Parliament and people of Jamaica. But in every other case, that is, in ordinary bills that come to the Parliament, then the words of enactment should be the Parliament of Jamaica. Mr. President, it further recommended that an act be passed prior to the tabling of the bill for the establishment of the Republic of Jamaica and other matters to give effect to the recommended new words of enactment. And I raise this point because the question of timing was raised in another place. And I wanted to take the opportunity to emphasize the issue of the words of enactment really became a public issue, or an issue being discussed in the public and certainly in legal circles and in the Parliament when Queen Elizabeth passed. Then it became a question of interpretation. Is it better to does the Interpretation Act simply allow us to replace reference to the king? People had different views. Lawyers had different views. And I always very lightly say in different circumstances that the only sector that has as many differences of opinion as lawyers are economists. It's the only other people who tend to have a view, and a considered view, with differing results in so many iterations and from so many perspectives. Law and economy stand on their own. But the point is, Mr. President, that whatever the view was, it is agreed that an amendment to the Constitution would make the matter clear, and certainly the vesting of autonomy and authority, rather, of Parliament in the enacting words bring the Jamaican Parliament and bring the laws which we make more securely and from a national identity perspective, more authentically within our space. And, Mr. President, it really has been felt strongly. And the more I hear it discussed, the more confident I feel in espousing the position that it will be that much more evocative when we become a republic. And that bill, that amending bill for the Constitution, is enacted by words which reference the Parliament of Jamaica. I believe it is not only a logical point, but it is quite clear that the timing makes sense. Mr. President, I'll now examine the bill clause by clause. Clause 1 provides for the short title to be cited as the Constitution Amendment of Section 61, Act 2024. Clause 2 provides for the amendment of Section 61. It has 5 subclauses. And the provisions for bills to be presented to the Governor General for assent is being removed from all the subsections and replaced with provisions for every bill to be presented to the Parliament. So not to the Governor General, to Parliament. The words, "the Queen's Most Excellent Majesty," is being removed from the words of enactment of all categories of bills presented to the Parliament and to be replaced with the words, "the Parliament of Jamaica." Provision for enactment of bills under Section 50 of the Constitution is being removed because the Section 50 was actually repealed in 2011. Accordingly, subclause A amends subsection 1 of Section 61 by 1, the deletion of the words "the Governor General for assent" and substituting therefore the word "Parliament." It also, 2, deletes the words "or a bill for an act to which Section 50 of this Constitution refers." And as I just said, Section 50 was actually repealed way in 2011. And thirdly, subclause A deletes the words "the Queen's Most Excellent Majesty" and substitutes therefore the words "the Parliament of Jamaica." Subclause B provides for the amendment of subsection 2 by deleting the words "the Governor General for assent" again and substituting it therefore the word "Parliament," and the words "the Queen's Most Excellent Majesty" with the words "the Parliament of Jamaica." And subclause C provides for the deletion of subsections 3 and 4 of Section 61 and the substitution of a new 3 and 4, which read as follows: that every bill presented under Section 49 of the Constitution, other than a bill to which Section 49(3) applies, the new words of enactment will read, "Be it enacted by the Parliament of Jamaica, by and with the advice and consent of the Senate and the House of Representatives of Jamaica," or the House of Representatives as the case may be, "in accordance with the provisions of Section 49 of the Constitution and by the authority of the same as follows." While every bill presented to the Parliament under Section 49 and to which Section 49(3) applies, the new words of enactment would read, "Be it enacted by the Parliament and people of Jamaica, by and with the advice and consent of the Senate and the House of Representatives of Jamaica," or the House of Representatives of Jamaica as the case may be, "in accordance with the provisions of Section 49 of the Constitution and by the authority of same as follows." And this is, of course, recognizing that there are bills that only go to the House of Representatives, and there are bills that are passed by both the Senate and the House of Representatives. And as I had explained earlier, those which require a referendum, which is where 49(3) comes in, for those enactments, the reference will be to the Parliament and the people of Jamaica, referencing the fact that there is a broader process which is implemented. Mr. President, subclause B provides for the amendment of subsection 5 by deleting the words "the Governor General for assent" and "the Queen's Most Excellent Majesty" and substituting the words "the Parliament of Jamaica." And subclause C provides for the amendment of subsection 6 by inserting immediately after the word subsection 3 after subsection 4. So, Mr. President, the discussion is somewhat technical, but that doesn't remove what I think is the emotional importance of this bill that is before us. It is essentially removing the monarchical reference to every bill which the Senate addresses our mind to every Friday that we sit here, and replacing it with the Parliament of Jamaica, and in such circumstances where a referendum is required, the Parliament and the people. That is powerful, Mr. President. It's powerful. And so it is that this is a part of our process whereby we implement together a constitution that resonates with the people of Jamaica and inculcates a sense of identity, a sense of pride, a sense of ambition, and ownership of our national constitution, institutions, and laws. So, Mr. President, this bill takes us forward in this process. It will ensure that the Constitution is amended to ensure that at that time, the bill establishing Jamaica as a republic will contain words of enactment that are commensurate with the autonomy that is consistent with the republic status. I'm restating what I stated earlier because I think we need to hear it, we need to internalize it, we need to understand it. That is the importance of this bill. So I want to, on that point, Mr. President, commend to the members of this Senate the bill that is before us for their consideration and approval, as it seeks to express the absolute lawmaking power of the Parliament of Jamaica and represents our very first legislative step on our road to republic. I thank you, Mr. President.
Thank you very much, Minister. And I saw a lot of excitement in your presentation, pride in your presentation. Yes, Senator Lambert Brown.
Thank you, Mr. President. Thank you, sir. I don't know if it's excitement I saw. I saw a struggle to explain what the minister described as technical issues. And it's not unusual for the minister to struggle that way. But I saw, that is what I saw in her response. And I can understand. I can understand. I can understand. Mr. President, I crave your indulgence, just before I address this bill before us, to place on record my congratulations to the leader of the opposition on his birthday, which he celebrates today. He's a friend of mine who has sat in the Senate with me on that side and on this side, and we have worked together. And I am very happy that he sees another birthday, and I hope that his position will be changed by the next birthday. That is, he will no longer be sitting on this side of any chamber that he sits, but on that side. I'll come into that. I come to that. So happy birthday, Mark Golin. Mr. President, second thing I wish to crave indulgence is to express my own appreciation for the outgoing president of the Court of Appeal. He has graced us in the Parliament with his presence at the throne speech, and so too the incoming, well, not incoming, she's now the president, the new president. She has also graced us with her presence. In respect to the outgoing president, I remember a couple of years ago being invited in a matter I was involved with in the Court of Appeal, presided over Justice Panton himself, Justice Brooks, and Justice Dukaran, to sit within the well of the Court of Appeal, even though I was not an attorney. But the matter had to do with a work I had represented. The outcome of that case was written, the judgment was written by Justice Brooks. And I had reason the other day, with his demeaning office, to just look back at what the Privy Council said about his judgment. It described it, I believe, in about paragraph 12 of the Privy Council, the impressive judgment written by Brooks. And that's the nature of the man. That case was the famous Senator Gale UTEC case where a certain attorney went and presented all by himself, and lost. But that judgment of Brooks is referred to in almost every case before the courts these days, Senator Braham, having to do with industrial relations matter. And I really want to thank him, having, Mr. President, been aware that he's the son of a former matron of National Chest Hospital, where my mother worked with that matron. It's also interesting that the incoming Justice McDonald Bishop, is the niece of a very good friend of my mother who was departed. In fact, she was with my mother the night before she departed. That is the aunt. So I too share in the elevation of Justice McDonald Bishop and thank the champion of fairness, Justice Brooks, for his service to the nation. Mr. President, in respect to this bill, I heard a while ago that this is the first piece of legislation on the road to republic. I would not be sitting in the Senate if in 2002, on the road to becoming republic, P.J. Patterson had not changed the oath act. Minister mentioned it. But that was part of the road to the republic, because the oath at that time, President, required those of us who would come to this chamber to swear allegiance to Her Majesty, her heirs and successors according to law. And that was offensive to me. In all my time in the Senate, I have never read the prayers being proffered here because of certain words in that prayer. I wish to pray for the happiness of the cane cutter, the backside worker, the worker on the wharf, rather than a foreign head of state. It is those people's happiness that I mentioned first that would have brought me here, not that. So I start by saying, but for the change of the oath, I would not be sitting on principle. And I note recently, President, one of the number of black African descent members of Parliament of the United Kingdom government, in taking his oath, he did what Michael Manley did. He took his oath to the Queen under protest. One of the newly elected MP. But I have long had the view before he said that I couldn't sit in a parliament where I had to swear allegiance to Her Majesty, her heirs and successors according to law. So I thank P.J. Patterson and the PNP for the boldness in making that change in 2002. So that's the first step along the way to the Republic. Having said that, President, I'm aware that there's a Constitutional Reform Committee on which 3 members of the Senate sit. And 3 members of the Senate, there's a 4th. You and Scott Matley challenged me on this, you know. I know which 3. 2 King's Counsel and 1 who should be a King's Counsel. But by that time it will be called Senior Counsel as part of the Jamaicanization process. President, I didn't see this specific bill carrying the footprint, fingerprint, or DNA of my 3 colleagues who sit on that Reform Committee. I didn't see that as an outcome where the Reform Committee says, let's do this bill. And somebody said to me, I don't believe them, but they said it to me. They said, this bill comes to justify the fact that the ministry pays $4.5 million a month, $54 million a year for rent. That's the only reason why this bill comes, to justify that heavy cost of rent. 54 million reasons that are not necessary. It's not necessary. It's not necessary, President, not because I want to, some ministers don't say it, I want to maintain the monarchy. No, I am anti-monarchy. Not even Selassie as a monarch, I would uphold. I'm anti-monarchy, so don't say that. The mover of this bill, sponsor, when she sat on this side of the Senate, and Senator Gale, you recall the famous words, piecemeal approach to legislation. She was the mistress of piecemeal, or rather, she was anti-ANTI, not AUNTY. But I like the synonym. She was anti-piecemeal. She was anti-piecemeal. So for this bill to come as a piecemeal to the bigger constitutional reform committee work is surprising. And it's not necessary. And that is why, even though I didn't believe what the person told me, I have to reconsider my views. Is this a 54 million justification? You're paying so much rent, show me what you do for the rent. So this bill, as the minister says, seeks to change the enactment clause and to say the people and the Parliament of Jamaica. Mr. President, I was worried that what we were doing with this bill was to move to a two-stage operation of the passing of laws. That is, passed by the House of Representatives and passed by the Senate. But there would be no assent. I thought that that's what it meant. But clearly it doesn't mean that, Senator Bryan. Because as you're aware, section 60 of the Constitution, and it makes sense to read it, so the public as part of the education process for the public. Section 61 says, 60, subsection 1, a bill shall not become law until the Governor General has assented thereto in Her Majesty's name and on Her Majesty's behalf, and assign it in token of such assent. This bill is not proposing to amend Clause 60. So will Clause 60 remain in the Constitution in the face of this amendment we are proposing, which is why I come back to, let's not do it piecemeal. Let's do it together so we could look at the entire Constitution. Section 62 goes on to say, subject to the provisions of Section 37, 49, 50, which the Minister says was repealed, 56 and 57 of this Constitution, a bill shall be presented to the Governor General for assent, if and shall not be so presented unless it has been approved by both houses of Parliament, either without amendment or with such amendments only as are agreed to by both houses. And then 60 subsection 3 is very important. It says, when a bill is presented to the Governor General for assent, he shall signify that he assents. And then, Mr. President, the words that follow are very important. Or that he withhold assent. So the Constitution allows the Governor General to assent to the work of the Parliament or to withhold assent. And it's important, Mr. President, that we pay regards to to those words or withhold assent. Some time ago in Australia, the Governor General withheld assent on a bill. It brought the government down. Only very recently, in our African country of Kenya, both houses of Parliament had passed a bill, a financial bill, which created a lot of problems in the society. Gen Z demonstrated. The young people of Kenya came out and demonstrated. And some were brutally slain. That protest by the people of Kenya, after the Parliament had passed the bills, had to go through a process of assent. And the president of Kenya, whose party promoted the bills in the first place, publicly and officially refused to assent to the bill. The bill, though passed by the Parliament, was killed by the protests of the people. The protests of the people killed that bill and led the president to withhold his assent. So it's important that the assent be retained. I look to see in Trinidad, which is a republic in the CARICOM, who assents? The president assents. I look at Guyana, a longer republic in the CARICOM, who assents? The president assents. With this new bill, I think it needs to be made clear that the Governor General, until we change to the presidential approach, is not being made redundant in respect to assenting, because Section 60 requires that all bills would be assented to by him. Therefore, what is the purpose of this? To say the Parliament assent? If that's the only change, then I say to the government, there are a lot more things that are currently in need of attention. Just this week, the Court of Appeal handed down a decision as to whether or not Senator Dixon could go to a particular primary school, or Senator Scott Motley, or Senator Fraser Binns could go to a particular primary school to get education. The Court of Appeal it is who came out and said, freedom of expression. Freedom of expression. So, Mr. President, there's another urgent matter that I hope the Constitutional and Legal Affairs would have paid more attention to than coming with this that doesn't change the slice price of bread except that Berry has pushed it up. The Constitutional Court says that the government of Jamaica, and before Senator Fitzhenley asks, let me say, successive governments of Jamaica have been charging motorists fines that are illegal. And the Constitutional Court has ruled that the government of Jamaica is wrong in what it has done. I would have thought that an arrangement to pay back that money to the motorists, to the taxi drivers, to the minibus drivers, and since I'm part of the motoring public who got 2 tickets, 5,000, so they owe me a little bit. Should I charge me more? Maybe. Well, next week when you come with your bill, I will come back to it. Point I'm making is that the citizens of Jamaica, if we really want to Jamaicanize, look out for them first. Address the refund to them. They're entitled to that refund. Address that. Look after the people. Put the people first, not cosmetic change. Not because I support the monarchy, I don't. I don't. I wish us would have gotten rid of it from 77, when the Constitution, when the 7th clash. 4/7 clash, and Manley proposed constitution change. I wish we had done it all the time. Happy belated birthday. So, this constitutional reform process has been long. Along the way, President, why I say that this change is so just cosmetic, it is as Botox as Matt Gaetz was this week at the Republican convention. It is Botox as Matt Gaetz was at the Republican convention. Mr. President, laws in Jamaica are not just laws in Jamaica. I read a lot. Laws in Jamaica are not just made through the Parliament. Let me go to a particular piece of law, because judges, in interpreting the laws the Parliament passed, have that power, Senator Bryan, of establishing what is law. So the names Pratt and Morgan wasn't passed in the House of Representatives. It wasn't passed in the Senate. That law essentially says, if you're on death row for 5 years or more, you can't be hanged. But the Privy Council in 1993 ruled that that is the law of Jamaica. The Privy Council ruled that you can't hang somebody, latterly they rule that, unless it's the worst of the worst case of murder. That's Tringham, that's the St. Vincent case. So the Privy Council can make laws by interpreting the existing laws, laws which bind every court in Jamaica. Stare decisis, that's the term the lawyers use. So, you're going to change the enactment clause here. But you know what you're not changing with this amendment? The following words. The board humbly advise Her Majesty or His Majesty that the appeal should be allowed or dismissed or denied. So, our laws made in England at the Privy Council or wherever they sit has to get the approval of the King, which we are retaining notwithstanding this law which says if the Parliament passed a law, we won't say it was enacted with that consent with the assent of the king. But you can't stop by sticking to the Privy Council that the laws are, as such, the fruits of His Majesty's doing. Mr. President, let me read quickly for us something said in April of this year, arising from the Privy Council. This is what it says. His Majesty, that's King Charles, was pleased by and with the advice of his Privy Council to approve the report. And listen to the words that follows. And to order that those charged with administering the government of Jamaica and all others whom it may concern are to ensure that it is punctually observed and obeyed. So the king is saying that the award of the Privy Council of costs in that DJ Palmer Vibes Cartel case, he is ordering those administering the government of Jamaica to comply and obey promptly, punctually. We're not changing that. Because you don't want to go to CCJ, which don't require the king's ordering us. So, when I say you're coming to this thing piecemeal, you're saying, we in this chamber, if we pass the legislation and the other place pass it, we'll say, it's not an enactment of the king. But you do nothing to change the court system, which is in your hands to change. Because if the government, the Privy Council and the king, the queen told us in the Syringa Marshall Burnett case that you all brought against her, that we could change it by act of parliament. All it requires is for the government to bring legislation, which has already been drafted and brought by another government. And I guarantee you that at least one of the 8 on this side would vote affirmatively. I believe all 8 of us would vote affirmatively for the CCJ. So when you come with this piecemeal, anti-piecemeal, thing is where I stand. When you come with this piecemeal legislation, you still leave out those who interpret our laws. And the United Kingdom Privy Council, the Judicial Committee, have no power without the king saying, I order that this report be followed. So the question I have to ask, Mr. President, as you Jamaicanize, when are you going to get rid of the king? When are you going to get rid of the king with our law-making process? When? When you're getting rid of the king out of this law-making process? You can't go partway and let me say what you call Mark Golden. You can't be 1 foot in and 1 foot out. And I'm glad Mark Golden has renounced, or is in the process of renouncing. Because the oath that he took, well, I know what my position was from day one, you know. The oath that he took, and which you read earlier, Minister, says as follows. It's important that we all appreciate the lawmaking process in the country. And the oath that Mark Golding took, and the oath that Matthew Samuda took, and the oath that all of us took, whether you're born near Augustown, as in the case of Mark Golding, or you're born in London, as in the case of people sitting in the other place and in this place. The oath that we must take, and we do take, and which I hold to, is as follows. So, Charlie, when you say Mark British, remember that you and him take the same oath, which is, I do swear that I will be faithful and bear true allegiance to Jamaica, that I will uphold and defend the Constitution and laws of Jamaica, and that I will conscientiously and impartially discharge my responsibility to the people of Jamaica. So help me God. And as you can affirm, but it's a space. Mr. President, I saw TikTok recently, as I close, where a member of the South African Parliament struggled with the word conscientiously. It's not unique to us. And I always fear that if I had to take the oath, I might struggle with conscientiously. I don't, and I haven't, but it's a big word. And as I sit, I remember, I think it's 2017, a minister in the new government was at King's House being sworn in. And Senator Sinclair, he was the oath man in the parish council. He was given an oath to read. And he read it out. He read it out, which included, I'm talking about Minister Audley Shaw, which included the words, allegiance to her majesty, her heirs and successors, according to law. King's House had to scramble to find the proper 2002. So what I'm saying here, let's change up. Let's go towards the Republic. Let's pay attention to the committee's report. Let us do that. And let us not come with a piecemeal so we may applaud the people champion-like to say we're going to do this. But end up, really, just a Botox shot. Because the reality is, every decision that comes from our laws that are interpreted by the Privy Council has to be, will humbly advise His Majesty. And His Majesty will issue an order to the government of Jamaica. Change that. Let's go to the CCJ. Change that. Let's not come with both tax legislation. 2 clauses. We are not going to oppose your decision to bring it, but we're putting it in context. We needed more than 2 clauses. We need you to say we're going to abolish the Privy Council, we're going to the CCJ. We need you to pay attention to the issues because the Jamaican people are becoming aware of their rights. And I could enlist Senator Braham. One right which says that even company have a right to challenge on environmental issues. So, Mr. President, I thank you. I didn't know I was going to be so strong to stand all this time. Now I'm going to have to drink your water. But Botox is not it. Give us the full meal, not a piece meal. May it please you, Mr. President.
Thank you, Senator Brown. Senator Sinclair? I'm sorry, Senator Braham? Senator Fitzhenley? Senator Fitzhenley?
President. Thank you. President, thank you, sir. I recognize that from time to time when we debate matters of national importance concerning, for example, an amendment to the Constitution of Jamaica, sometimes there's a dissonance given the personal crisis that people in Jamaica, some sections of Jamaica, are facing, in particular southern Jamaica. I therefore wish to begin my presentation by thanking God that He spared Jamaica the worst of Hurricane Beryl. And I want to say to my fellow Jamaicans who were severely impacted, don't give up hope. That the government of Jamaica understands your plight. We know your challenges, and we have been moving to assist. And as a matter of fact, as I speak, the Prime Minister is on his feet in sections of southern Jamaica, Manchester and St. Elizabeth in particular, not only donating houses to Jamaicans in need, but also taking another opportunity to assess how the Jamaican state is moving to assist people who are facing challenging times. And I happen to know as well that our private sector stakeholders who were petitioned by the Prime Minister are also on the ground giving real-time assistance to Jamaicans who are in need. So I said to my fellow Jamaicans that we are sensitive to your plight, and we are moving to respond and to assist you to build back stronger. On the substantive matter, sir, I've assumed my feet to make my contribution to debate on this bill that is entitled An Act to Amend Section 61 of the Constitution of Jamaica, a bill which proposes to make way for new words of enactment. And as our Senate leader so capably adumbrated, it is the first legislative step. It's not piecemeal, it's the first legislative step in a series of proposed amendments intended to give effect to a constitution enacted by the Parliament of Jamaica and with the support of the people of Jamaica. And while this process on the face of it may appear technical in nature, the enacting words are important to underline and underscore the supreme power of the Parliament of Jamaica in enacting matters as opposed to external forces. Section 61 of the Constitution sets out the words of enactment that must accompany every bill. The current prescribed words of enactment state inter alia, be it enacted that by the Queen's most excellent majesty, and I gather the passing of Her Majesty has caused a rethink of how we approach such wording, not just in Jamaica, but across the Commonwealth jurisdiction. So again, it's not a piecemeal approach, but it is an administration responsive to developments of our time. I take note as well that Clause 2 creates a basis for amendment of Section 61 of the bill. It proposes to delete the words Governor General for assent and substitute such with the word Parliament. Clause 2 also provides for the words the Queen's most excellent majesty to be substituted with the words the Parliament of Jamaica. Procedural amendments, some may say, but I find the amendments or the proposed amendments quite substantial given our history. That is where we are coming from. where we are currently at and where we intend to go as a Jamaican state in terms of establishing and underscoring the Jamaican identity. The amendment, which underscores the supreme legislative power of the Jamaican Parliament, has my total support, and I'd endeavor to indicate.
1 minute, Senator Fitzhenley. Yes, Senator Brown.
The member has indicated that the Parliament is supreme. I thought that was the Constitution of Jamaica, but then again,
Thank you. Senator Fitzhenley, continue for me, please.
Yeah. I recall on the occasion of a visit, the visit to Jamaica of a member of the monarchy, Prime Minister, the Most Honorable Andrew Holness, indicated that in terms of the trajectory of our head of state, we are moving on. This bill is part of the process of indicating that this is an administration that is not just filled with talk, because this has been talked about for a long time, but we are prepared to take the credible legislative steps to move towards supporting our words and establishing the Jamaican identity. And, you know, I hear Senator Brown taking umbrage with what he says is a piecemeal approach to the matter of constitutional reform. But for some context, I wish to recall that this matter of changing the words of enactment has been discussed for a long time. As a matter of fact, it was in the early 1990s that the Constitutional Commission of Jamaica had contemplated adjustments to the words of enactment, that they be modified to refer to the people and the Parliament of Jamaica. That amendment under the erstwhile PNP administration did not materialize. I believe it is good that this administration will take a step towards getting this amendment done, which has been spoken about for decades. The amendment we propose to pass today will ensure that any future suggested law, including bills to depose of the monarchy as head of state, will bear the words which countenance the new status that the government of Jamaica is on record as indicating that Jamaica aspires towards. It's an important move we're making today, which, in my view, supersedes more than symbolism. On the matter of constitutional amendment, and the senator who spoke just immediately before me had raised the matter of Jamaica moving towards Republican status. It is not lost on me that anytime I address this Parliament, I speak as well for sections of my generation who care about matters of government and governance. So I wish to say a few words on the issue of Jamaica deposing of the monarchy, the UK monarchy, as head of state. This is a matter that has been discussed for my entire lifetime. And I'm among a generation that is not bitter about our colonial past, but we are sensitive to and aware of what transpired. The great evil which was done to our ancestors by agents of the UK monarchy. And it is my conviction, sir, that the sooner Jamaica deposes of the UK monarchy as head of state, the better. And again, it's not a matter of mere symbolism. It is important to our identity as a people. Senator Brown raised the question of when are you going to get rid of the king? I put it to you that the administration has taken credible steps in this regard. However, it certainly appears to me that the process has been delayed, to use a very kind word, based on the posture of the opposition. And I take the opportunity to urge the opposition to put ego.
Senator Brown, hold on. Let the minister, let the senator complete his presentation. Problem. Senator.
I'd urge the opposition to put ego aside if in fact it is prevailing. Put any other consideration to the back burner and let us move forward with the process of Jamaica deposing of the UK monarchy as head of state. I hear the opposition leader on platforms across the country saying words to the effect of, comrades, time come for us to depose of the UK monarchy, time come for us to do X, Y, Z. I suggest that he act on these words. As a matter of fact, I wish to read into the record, sir, words which were uttered in April 2022 concerning the matter of Jamaica deposing of the UK monarchy as head of state. And I quote, "We, the PNP, have made it clear we are prepared to proceed, and we'd like to do it more quickly. As a matter of fact, we'd love to do it this year. But I think the Prime Minister has indicated that he's working within a 2-year phase. But we want to get it done. So we'll cooperate and he will have our support. We think it's an important step for Jamaica as an independent country to have a Jamaican as head of state. Such a move is urgent and a fundamental governance issue for our country." Words uttered by the opposition leader, who 2 years later, subsequent to the Constitutional Committee doing its work, he has proposed to itemize a whole list of demands before agreeing to do what he had committed to do 2 years prior thereto, that is having the UK monarch deposed as head of state in Jamaica. That sort of posture, sir, I think might best be contemplated as a case of untrustworthy flip-flopping by the opposition and the opposition leader, who last we heard was under the force of law of the United Kingdom. I urge the opposition leader to reconsider his posture and quit from a countenance of flip-flopping, which will convey to the Jamaican people that we can't take him as a man of his word. I want to say to the opposition leader via you, sir, we are aware that he's in a position where he has 1 foot in and 1 foot out of King Charles's kingdom. But it is time to be a man of his word. Cut out the unnecessary flip-flopping, the ego and the ostensible arrogance, and don't be an impediment towards the government of Jamaica and the Jamaican people being successful in having Jamaica remove the king as our head of state. And again, the word piecemeal was a consistent theme in Senator Brown's presentation. But I wish to bring to the senator's attention and the attention of the people of Jamaica that, there are erudite members of the opposition, including former prime ministers, who have intimated that constitutional reform is best achieved when done on a phased basis. I don't often agree with the former Prime Minister who recently intimated such, but on that matter, I am a DDM. I entirely agree that it's time for us to move forward with the process of having Jamaica depose of the UK monarchy as head of state. And I wish to make one final comment on that matter. I submit to the Parliament of Jamaica that history will judge the current opposition and the opposition leader most unkindly should they continue to posture in a manner that effectively is delaying the process of Jamaica having a Jamaican appointed as head of state. I said to the opposition and the opposition leader, let good sense prevail and allow us to take this important step of underscoring our identity as a people. I wish to make a general comment on the matter of constitutional reform. I commend the CRC, a bipartisan committee, on the work just done. I think there's evidence of significant thought being put into the process, and that when many of the recommendations are acted upon, they will take a significant step towards moving forward our democratic processes in Jamaica. But again, when I contemplate the Constitution of Jamaica, and I hear members of society, including the leader of opposition business in the Senate, who is not here today, he likes to say that he's a constitutionalist. Yes, he likes to say he's a constitutionalist. But I'd invite him and others of like mind to consider whether the current Constitution of Jamaica is fit for purpose according to the current challenges of our time. I am of the view that it is not, and therefore it is impatient of further delay that we move forward with the process of significant constitutional reform. Again, a former Prime Minister once said that the law is a tool of social engineering. Those who present themselves as impediments to the process of significant constitutional reform, I'd impress upon them to contemplate whether the Constitution in its current form provides an appropriate fundamental plinth for us to address some of the major challenges of our time, including national security. I believe that the supreme law of the land must be abided by in its current form. However, significant work remains to be done in terms of making the document fit for purpose according to the challenges which face Jamaican society currently. On the matter of amendments to the Constitution as well, a member of the lower house mooted in the public domain well, let me say this. I've always thought it important that I maintain a mindset which is not influenced merely by partisanship, but I retain the ability to espouse that which is right and appropriate and in the interest of the Jamaican people. I have long been of the view, sir, that one who aspires to be Prime Minister of Jamaica, or who in fact is leader of the executive, should be a Jamaican citizen and a citizen of Jamaica only. Not only because it is the morally right endeavor, but because the issue of such an important, the scenario of such an important office holder having dual allegiance and split loyalties may well bring to the fore concerns regarding whether that individual has placed himself in jeopardy of offending the Hersey law. That's the law which seeks to forbid betrayal of one's country. Indeed, the 1870s Foreign Enlistment Act in the United Kingdom forbids citizens of another nation, apart from the UK, acting in military defense of a country that is not the United Kingdom or a country that the UK is at peace with. So when I hear the opposition leader commenting that he's merely intending to renounce his UK citizenship because he does not want to cause controversy or does not want to adversely impact the political fortunes of his candidates, I find that sort of excuse for taking what is an important step, announcing intention to take an important step, to be the most objectionable exercise in political expediency that I have seen in a long time. And for the opposition leader to say he is merely intending to renounce because he does not want to badly affect his party or adversely impact his candidates, I believe is an insult to the people of Jamaica and an insult that the people are unlikely to forget. It is my view that the Constitution should be amended to mandate that the aspiring or current leader of the Jamaican executive must be Jamaican only. I am strongly of that view, and I've long been of that view. And, you know, I heard Senator Brown's presentation, and I saw much irony in it. The senator spoke about not reading the prayer in Parliament or, you know, being particular about swearing allegiance to the monarch. But here's a senator addressing the Parliament of Jamaica and making those bold statements when in fact he's part of an organization which, last we heard, was being led by an individual who is under the force of British law and a subject of the United Kingdom. That, sir, is a good example of hypocrisy that oftentimes marinates the contribution of the member. Hypocrisy. 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 Hypocrisy.
You should come with the receipt number. You should have come with the receipt.
I want to burn you. So again, sir, I've heard the contribution of Senator Brown, but in summary, I'd urge the opposition to desist from a posture of flip-flopping, desist from a posture towards the process of establishing the identity or underscoring the identity of the Jamaican state, resist the urge to take into consideration which side gets it done. Because the truth of the matter is that this has been spoken about for a long time. And my generation, there are sections of which we are impatient with the process of temporizing, vacillating, which has stymied this process coming to fruition. Partisanship aside, I'd encourage your opposition to go back to the drawing board and support the various processes and legislation which are brought to the Parliament of Jamaica by the government of Jamaica as we move towards the posing of the UK monarchy and reaffirming the Jamaican identity. This bill has my support, sir. I thank you. And as usual, may God bless our country.
Thank you, Senator Apka Fitzhenley. Senator Dr. Professor Morris. St. Mary, man. Come, young man. Mr. 1 minute, Senator Morris. Come now, Mr. Microphone. Thank you, Senator Morris. Go ahead, please.
Thank you, Mr. President. And I rise to make my contribution to this debate. But, Mr. President, allow me, on a proud day like this, to extend my congratulations as well to Justice Marva McDonald Bishop for being elevated to President of the Court of Appeal.
Senator Morris, you know that you have had a Chief Justice from the parish as well, right?
Yes.
Oh, which is who?
Zayla Bacala.
No, Zayla is from St. Mary. Her husband is from St. Mary.
Okay.
But Zaka was actually from Highgate.
Okay.
So this is the second.
So greatness is deeply embedded in St. Mary, Mr. President. And I got a WhatsApp from former Senator Robert Montague to confirm that. Mr. President, when I was in first form at St. Mary High, Justice McDonald Bishop was my senior. Likewise, Robert Montague. And so, you know, I'm very proud to see her elevation to this office because, you know, from last year, St. Mary High School has been on a roll with Professor Vereen Shepherd being re-elected to the third committee. And this year, you know, me being re-elected to the UN Committee on the Rights of Persons with Disabilities, the only high school in Jamaica that has 2 members of that institution being a part of a UN treaty body system. And now we have the president of the Court of Appeal, and commendations are in order. Mr. President, every time that I participate in debates in the Senate regarding any amendment to the Constitution, I deem it and treat it extremely serious because I would want to let Senator Fitzhenley know that we have what we call constitutional supremacy, not parliamentary supremacy. I want him to know that we have constitutional supremacy, not parliamentary supremacy. Probably that might be a slip of the tongue or a stated underlying intent. But we subscribe to the precepts and dictates of the Constitution. And Mr. President, you know, as I listened to Senator Fitzhenley in his presentation, there are some things that he said that really ached me. And I'm not in reference to what he was saying about the leader of my political party, because for me, what he said is neither here nor there. But when he can stand up and say that he and his generation are not bitter about the colonial past, it gives me grave concern. Because it is the colonial past that established and implemented slavery in our country. It was a part of the colonial legacy that caused Paul Bogle to be killed. George William Gordon, after which this house is named. And if you are not bitter about that, then it gives me one more reason to look at you differently. Differently. Because I make it absolutely clear that I want to do everything to get rid of our colonial legacy. To get rid of our colonial legacy. And so, Mr. President, when I hear Abka talk about flip-flopping, I said to myself, Abka, you're a just comer, you know. You're a just comer. And there's a lot for you to learn, because I have no doubt that you read widely. No doubt that you read widely. But you need to read some more about who flip-flop when directions were given in the late 1980s for discussions to be held about Jamaica and the final appellate court, the Caribbean Court of Justice. You need to know who flip-flop when discussions were held with the leader of your political organization then, with the then Prime Minister in the early 2000s as to how to move forward with the constitutional amendment, because we were set on a particular path. And we need to know who flip-flopped in 2011, where the constitutional amendments were concerned. So, you don't come here and talk about people flip-flopping. So, Mr. President, I am very concerned about those utterances. But, you know, Mr. President, the legislation that is before us have me very concerned. And I was concerned before I came in the chambers. And when I heard Minister's presentation, it gave me even greater concern. Because I was of the view that the amendments were merely to change the enactment clause to ensure that our legislation recognizes the people of Jamaica and the Parliament of Jamaica. But when I read and I saw in the legislation that there was going to be an amendment that would replace the Governor General's assent in terms of the wording, I was very concerned. But then Minister came and affirmed that as a major intent of the bill. So, Minister, I want you to tell me, I want you to tell Jamaica, if this bill is moving one of the tiers of our governance process by removing the assent of the Governor General from legislation. Is it that the Governor General, when we pass this bill, is it that the Governor General will no longer be required to give assent or to withhold his assent in terms of legislation? Is that the regime that is going to commence, say, Monday morning? Is that what is going to happen? I want to know, Minister. I need clarity, Mr. President. Really need clarity on it. Because, you know, when our constitutional, the mothers and fathers of our Constitution framed it in the early 1960s, there are some interesting features that are built in the Constitution. And so if it is that you are going to make modification or amendment to one area, you have to look at the other areas of the Constitution that it is likely to impact. Because you can't make an adjustment in one area and don't look to see what are the implications in other areas. And that is what concerns me now, because this bill, based on what Minister is saying, is going to remove the assent of the Governor General? Well, I want to know. I want to know. I want to know. I'm asking the question. Also, you're going to repeat it? Okay, you're going to clarify. Okay. All right, I'll wait, Minister. But, Minister, you know, I am a creature of the Constitution, and I want to make sure that whatsoever we're doing here today fits within the Constitution. Because I have sat here on a number of occasions and seen legislation brought here. The government was warned. The government was warned, and because of hubris, the opposition was ignored. The opposition was ignored. And we see the legislation passed in the Parliament, and we have seen the subsequent results. And so I want to, I am even more emboldened now to make sure that we adopt a scrutinizing look at these legislation that connects to the Constitution. Because as a member of the Senate, I swear to uphold, well, I affirm, Senator Sinclair, I affirm to uphold, and the Governor General affirmed too, to uphold and defend the Constitution. And I want to make sure that what is taking place here today is not going to weaken the provisions that are in the Constitution and were meticulously crafted by our forefathers. I don't have a problem, as I have said, with us doing away with the reference to the monarchy. I want to get rid of everything relating to them in Jamaica right now. Right now. And that include moving away from the Privy Council. So don't come and tell me that we're not supporting the effort to modernize and do the reforms to the Constitution. We are supportive of that. So it's falsehood that was made by Senator Fitzhenry about the expressions of the leader of the opposition in terms of his stance on constitutional reform.
Senator,
okay.
120. Leader.
118, Mr. President.
120 somewhere.
Might the Senate be permitted to sit beyond 1:30 to complete the business of the
Thank
day?
you very much. Senator, I interrupted you because I thought it was a nice little period of time there. The question is that the Senate be allowed to sit beyond 1:30 to complete the business of the day. Those in favor? Thank you, Senator Morris. I'm not going to interrupt you again.
No, Mr. President, and I won't be much longer because, you know, but, you know, I just want to end by pointing out that we are not, and have never been, opposed to constitutional reform. And I know that others of my colleague will speak to that more fulsomely, but just to say that a critical part of our constitutional reform agenda is that we are saying you can't go and move away, move the king, but yet still you are hanging on a fundamental part of the king's legacy, which is the Privy Council. I can't see us having that total and complete reform without moving away from the Privy Council, which is a fundamental part of the colonial legacy. And now I understand why Senator Fitzhenry is saying that he's not bitter with his...
1 minute, Senator Morris. Senator Fitzhenry.
I note a suggestion made by Senator Morris that I had indicated that I'm not bitter or I see nothing wrong with our colonial past. No. I believe he's misleading the Senate, and it's important that the record be set straight. Because what I indicated is that while a mindset of bitterness is not encouraged, we are aware of the wrongs and the evils perpetrated and the need to have it corrected. I stated that very clearly. So I would insist that the member not be allowed to mislead the Parliament of Jamaica, as the opposition has been for the past few weeks. Thank you, sir.
Senator, I am about to rule on it. That is not a point of order. If it would more be by way of a point of clarification. That's not how you rose. Please continue, Senator Morris.
Mr. President, I am certain of what I heard because it resonates in my mind and will continue to echo in my mind as I leave here today, because I'm going to go back for the tape, because we have one of the good things about the modern times is the history, the fact that we have these things are recorded for posterity. So, Mr. President, I anxiously await the minister's response and clarification, because I want to leave here today clearer than I came in as it relates to this piece of legislation, because I came in concerned that it was much to do about nothing, and I am leaving with a similar opinion. May it please you, Mr. President.
Thank you, Senator Morris. Senator, thank you, Senator Morris. Senator Ransford Bram.
Mr. President, I want to join, with your permission, in congratulating the new President of the Court of Appeal, Madam Justice McDonald Bishop, and to thank Mr. Justice Brooks for his service.
We're going to turn off both. Just use one of them, but maybe you need to just okay, yeah, just use that one alone, Senator Brown.
Yes. I want to join in thanking Mr. Justice Brooks for his service, and indeed, he delivered himself with great dignity and treated the public and the profession excellently. And as Mrs. Justice McDonald Bishop embarked on this tenure, we give her support, and we look forward to the additional that she would bring to the job, building on the foundation of illustrious others that went before her. The other thing is that my Senator Lambert Brown, in his presentation, said a few things. And he started out by suggesting that the ministry responsible for the bill, that the bill was brought to this Senate for the purpose of justifying the rent that the ministry pays for the place that they occupy. I thought that that was an unfortunate comment. One, there's no evidence to support it. And I go as far as saying that it is not true. And he knows it's not true. And he ought not to say it. And the second thing,
I said, someone said, he's attributing to me what I said, someone said. But the 54 million was said in the Parliament, $4.5 million per month.
It's not to a point of order. Continue, please, Senator Bram. Senator Bram, could I ask you just to speak a bit louder because we're not picking you up? You're right, that's complaining.
the fact that someone tell you falsehood is no justification to repeat the falsehood. And I know Senator Lambert Brown knows better. He shouldn't do it because it is disrespectful to, even if you decide that the minister is not deserving of respect, then the staff of the ministry who would work day in and day out for the people of Jamaica deserves to be treated better. And I don't wish to support that statement. Thirdly, what I would say is that the Constitution has in it built in certain levels of protection. There are levels of difficulties involved in the changing of this Constitution, Mr. President. In some countries, for Belize, for example, it is fairly easy to change the provisions of the Constitution when they seem to only have one particular procedure. In Jamaica, under our Constitution, they seem, and I think it's correct to say, that there are 3 tiers. And so they say that there are provisions in the Constitution that are deeply entrenched. There are provisions in the Constitution that are entrenched, and there are provisions that are unentrenched. And so the unentrenched provision is by far the easiest to change. And there are some of those in the Constitution, Mr. President, that they are not entrenched. And one of them is Section 61, that is not entrenched. And so you need only a majority of the Senate, and I put it that way. It's not a majority of a quorum, but a majority of the entire Senate. So that means while you could have an average bill being passed, say, by 8 persons or 8 members, that's a majority of whoever is present forming the quorum. But a constitutional bill, even in an unentrenched situation, requires a majority of the entire Senate. So what is that majority in this case? My maths is not the best, so I'm not going to trespass there, but it's certainly more than 8. That's what I would say, and leave the president to work out what that majority is. But even the unentrenched provision is treated somewhat differently from regular legislation. And so the deeply entrenched situation, Mr. President, requires a 2/3 majority of the Senate and the House. It requires a timeline that the bill to amend the Constitution has to be laid in the Senate and in the House before it can be passed. And then it requires that you have to go to the people. And they say that is deeply entrenched. And of course, you'll see the absolute difficulty in amending provisions like that. And one of those, interestingly, is our head of state. and our head of state as stated by the parents of the Constitution. Mr. President, is the monarchy. And that is a provision that is deeply entrenched. And therefore, it cannot be changed by a majority of the senators and houses of representatives. And so that is the most difficult. The easiest, the unentrenched. The most difficult, the deeply entrenched. And the next most difficult would be the entrenched, which would require a 2/3 majority of both houses, and of course the delay in laying them in the bill in Parliament. And so that means then that at least in the Senate, you would need for the entrenched provision and deeply entrenched provisions, possibly, support of both sides to have those amendments, Mr. President. And that is the question of instituting a new court to replace the Privy Council. That is a provision. To do so, it means that you would have to pass the law at the very least to be an entrenched provision, which would require support of, in the Senate at least, both sides of the House. Now, the question is, why did I say that? I say that, Mr. President, all of that, because Senator Brown raised the question as to why we are not changing Section 61. On the face of it, Section 60, why are we not amending Section 61? I use amend and change interchangeably. So, I'm sorry, 60, beg your pardon, thank you. Why no change is being made to Section 60, which... Yes, thank you. Yes, my interpretation of what he was saying, he was questioning the reason why there is not a change to Section 60. But at least allow me to tell you what my interpretation is. If you don't like it, answer. Right? But I want to tell you what my interpretation is. The way I understand the Senator Lambert Brown position is that you are changing 61, you're amending 61, and it seems to him that if you are doing the 61 amendments, then changing 60 would be also appropriate. That's how I interpreted what he said. Okay. All right. So you didn't say that you had a problem with 60? Really? Oh dear. So I need to look for my notes then, because no. Senator
Brown, just address the president and do not be distracted.
Thank you.
And if you want to make a point, you don't necessarily have to refer it to the person who is now denying that he said it. Yes. Just say it in a vacuum. No, I'm not. But I'm not saying you did. I've just said that you are. I'm saying that you are saying that you denied saying so, which is what you are doing. Senator Brown, please continue.
So, as I understand it, without referring to any particular person then, the section that is being sought to be amended is that section that says that the Parliament's action in terms of bills and that the words of enactment should be it enacted by the Queen's or the King's most excellent majesty by and with the advice and consent of the Senate and House of Representatives of Jamaica and by the authority of the same. And so the reference to the Queen or the King in that enacting clause is on the face of it in keeping with the fact that we have a monarchy. But as I said to you earlier, we are not in a position to amend and remove the monarchy unless the deeply entrenched procedure is followed. That's the monarchy. To replace the monarchy with a president of Jamaica. You cannot remove that unless you follow the deeply entrenched procedure. However, in dealing with this provision, 61, it's not deeply entrenched or even entrenched, and therefore can be changed using the unentrenched procedure, which is a passage of the legislation by the necessary majority, absolute majority in either house. And that would be sufficient to amend, Mr. President. And so the question is why I want to amend this now or not. And I can see the logic for amending it now, in the sense, apart from the fact that it has a sentimental value, so that you don't have to read the bills to say, and the acts to say it in the way it's set out. But when the bill comes to amend the Constitution to remove the king, when it comes, going through the deeply entrenched process, if this is not amended, that bill will say, my layman's thing now, not well, I suppose I'm not a layman. What it will do, if you don't amend it, when that bill or act is passed, the act to get rid of the king will say, be it enacted by the king's most excellent majesty, etc., etc., we are getting rid of his most excellent majesty. And it has a certain philosophical incongruity about it, that it would, and you know, there is a big debate about the need to repatriate our constitutional instruments, because it is said, and it is true, that the Jamaican Constitution, Mr. President, is enacted as a schedule to an act of the United Kingdom Imperial Parliament. And so there are many who argue that they find that offensive. So when we eventually start the amended process by removing the king, Mr. President, what it is doing, it is this Parliament that would be doing the amendments and in a way repatriating the instruments to Jamaica. And it would be most appropriate at that time that it simply says the Parliament and the people of Jamaica doing certain things. Instead of saying we are repatriating or we are removing the king with the king's most excellent permission, we are saying the people of Jamaica and Parliament of Jamaica is removing the king with the most excellent people of Jamaica. So that is why I consider the bill to be a value. It is a value. It is a value. It is of equal value to the change to the oath, Mr. President. And when we are going to amend the Constitution to remove the king, it would be excellent if we don't have to say the king was a part of removing the king, or that the Jamaican people choose to remove the king. And that is a beneficial thing. It is a beneficial thing. It's a beneficial thing. And you know, it's a beneficial thing. So that's why I support it. I support it because it is highly emotionally beneficial. It is symbolically beneficial. It's just beneficial. And therefore, it makes sense. Thank you very much. So the question, I go now to, I think it's a very good question. I thought it was a question raised, but my friend Senator Lambert said he didn't ask any question and he never said. So let me put it this way. To those who are asking the question, but you're still going to use the Governor General to assent to the bill. Why you don't remove that too? To me, it would be a good question if it was asked. But it was not asked, but I'm answering it. All right. All right. Well, so what you getting hot under the collar for? Calm yourself down, man. Calm down, calm down, calm down. So the question is properly asked. You're going to have the Governor General sign it. But you know, Section 60 is, on the face of it, if you look at it by itself, is also unentrenched. And so you should, on the face of it, be able to remove it. But it is caught by other provisions that are deeply entrenched. And indeed, one of them, if I may give you an example, is Section 49. Section 49, no, those were excellent arguments. Excellent. I am expecting success. They sound just as persuasive, don't it? All right. There you have it. But, so, Section 49, because you see, when you look, and you know, the argument as to whether the Constitution is supreme and all of that, it is due to Section 2 of the Constitution, which says, subject to the provisions of Section 49 and 50 of this Constitution, if any other law is inconsistent with this Constitution shall prevail, and the other law shall, to the extent of the inconsistency, be void. Now, Section 49, that it says it is subject to, is the amendment provisions. In other words, Parliament is entitled to amend the Constitution following the procedure in Section 49. So, let us see the point I wanted to make about Section 61 by looking at Section 49, if the question was asked. Section 49, subsection 3, Mr. President says, insofar as it alters this section, meaning Section 49, a bill, and I'm skipping a number of areas, a bill for an act of Parliament under this section shall not be submitted to the Governor General for his assent unless. So, even though you can remove the other part, the deeply entrenched part requires the Governor General assent. So it effectively, that is deeply entrenched as well. Section 61 is deeply entrenched. And that is why you could not simply by majority, as we are doing now, remove the assent of the Governor General, even though that would be similarly appropriate. But it can't be done until you go through the entrenched procedure to amend the Constitution. And so that is the reason, Mr. President. Well, I use it. So that section, as desirable as it would be, to change it at this time could not be changed until the full gamut is done, following the procedures for entrenchment under the Constitution. So, yes, if it was asked. And it wasn't asked. But 61 at this time, under this procedure, could not be affected. 60, section 61, yes. Yes, thank you. So that's what I would like to say on that. And then, Mr. President, Senator Brown also said one other thing that I found striking and is a part of the debate ongoing in judicial and legal and philosophical circles, and that is whether or not judges make law. And every time I hear an argument that judges make law, I get a little nervous. Because there are judges who feel that they do make law. My own view is that we continue to have what they call, certainly between the judiciary and the legislature, a separation of powers. And lawmaking is reserved for the parliament, the people's representative, and the judiciary is given the authority to interpret these laws. So, Senator Lambert Brown, in my view, said, and again is when they say I'm wrong, that the Privy Council made law, makes law. The Privy Council in Pratt and Morgan and so on was not purporting to make any law. They were purporting to interpret the Constitution as to whether the Constitution as presently worded would be applicable to Pratt and Morgan situation, and they came to the view that when the Constitution, when properly constituted, it is not appropriate. That is different from making law, Mr. President. And I'm saying it because I think I may have an opportunity one of these days, very shortly, where the discussion of the Caribbean Court of Appeal and the Privy Council will become a subject of discussion in this Senate. And I will reserve my comments until then. But one of the issues is your judicial philosophy. What is your judicial philosophy? Do you believe that you are restrained in your lawmaking powers and your job is to interpret the law? Or can you fill the gaps as what people are now called an apex court should have the power to fill the gaps when Parliament is either too lazy, too dunce, too slow, that a more enlightened third body is able to fill the gaps? And that is a judicial philosophy that some people have. And it needs to be debated because in my view, it is fundamentally disrespectful of the people. And so I could not sit down and hear my senator say that the Privy Council make laws, because we certainly do not want that to happen, Mr. President.
Speaker's time has expired.
Really? That's his...
Don't say that.
To allow him to complete his presentation.
You know, I was looking recently at the sitting in the law house, and they actually say, how much time do you need? 3 minutes, 5 minutes. And it's not a practice that we observe here, because we know that when we say, may the speaker's time be extended to allow him to complete his presentation, it is never really abused. May he? Those in favor?
No, Mr. President, only 1 or 2 more minutes. So that the point then, Mr. President, in relation to the bill that is before the Senate this morning, this afternoon, Mr. President, is the bill achieving a good object? Is it serving a good purpose? Is it in keeping with Parliament's power and authority? I am saying to you, Mr. President, and to those who are listening, that the bill serves a good purpose. That purpose is to ensure that we no longer have to refer to the king when we bring our legislation into power, into enactment and so on. And more importantly, Mr. President, to ensure that when we come to the stage to amend our constitution to remove the king, we don't now have to say we are removing the king with the authority of the king and by his excellent advice and good graces. And to me, that's a perfectly sensible thing to do. Thank you very much.
Thank you. Senator Fraser-Binns, we're just trying to get an understanding as to how many speakers we have. Minister, you could tell me how many speakers you have left? 2. All right, we're going to try and just you have 2. The clerk is it? Well, both speakers from the opposition I recognize as being persons that get to the point immediately, and so Senate, and so Senate. So let us try and finish the thing. We have something else doing after. There is something else to be done after, so we need to just try and move with a degree of alacrity because the staff was actually asking for a break. But leaders, Senator Scott Motley, Senator Minister, you want to just push ahead or you want to take a break? The staff is really asking for a break. It's 10 to 2. Okay, Senator, Madam Clerk, you okay with that? Okay, let us proceed. Senator Fraser-Binns.
Thank you, Mr. President, and I didn't intend to be long. And certainly after this discussion, I shall not be long. But Mr. President, I want to just make some quick points, and I'm so sorry that Senator Braham has left because my friends, certainly on the other side, believe that he has made a presentation of his lifetime in the Senate. And whereas I completely appreciate the academic discussion and the manner in which he sought to explain, perhaps more for our listeners, I think he has missed a substantial point and a substantial concern on our side. So this bill, amending Section 61 of the Constitution, I believe that the concern, certainly on our side, is whether this is an empty symbolism. Now, Senator Braham sought to give this view about the feel-good that comes with it when the time comes in the future for us to debate on the end of the monarch. But I want to say 2 quick things. One has to do with the fact that there is, in fact, an acceptance that we should end with the monarch. And I suppose this piecemeal approach, this step in this bill, is towards that. But I could not help myself when I sent for the prayer, because in my mind, if we are going to Jamaicanize our parliament and Jamaicanize our laws, then I believe a good place to start would be the prayer. Because the prayer, which doesn't need to go through this process, says, and I'm going to read a part of it. It says, "May be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the king." In fact, until recently we said the queen, and we made the effort to change it from the queen to the king. And if we're going to Jamaicanize, then I think we could have made the effort to change our prayer. On many occasions, request has been made. Certainly I remember former Member of Parliament, Raymond Price, who sought to have that change. So whereas I believe everybody welcomes any attempt to Jamaicanize our parliament, I think we can Jamaicanize our prayer. And it requires very little effort. Senator Braham, and I'm really sorry he's not in the chamber, but he mentioned that the reason for amending Section 61 and not Section 60 is because at Section 61, when the time comes, then we're going to say the people of Jamaica. Good point. But the irony is that the very accolation or adoration, for example, if I may say, that he wants to take away from the king is the same power that is still given or is still in the Governor General, who is the king's representative in Jamaica. So if we are saying that we do not want to reference the Governor General or the king, and we want to refer and we want to put forward our Jamaicans, which we rightly should do, then the irony of it is that the same Governor General is the one who has to assent, the one who has to sign off on the bill at the end of the day. And I found that to be ironic. In other words, Minister, because I can see and hear the comments. In other words, I do not see the mischief waiting until we come to the point where we do a full constitutional reform, which would include Section 60 and Section 61. And so, Minister, it is... that is correct. 61 cannot stand without 60. But the point we're making is that it really does not advance much. And I think that is what it is. I'm not going to use the term Botox as Senator Brown has used, but I believe that it really has not advanced the Jamaicanization that we're talking about. And I have to go here because Senator Fitzhenley went there. And again, regrettably, he's out of the chamber. And I like to talk when people are in the chamber so they can hear. But as we talk about Jamaicanization and putting Jamaica first and 1 foot out and 1 foot in, I was forced to look back at the oath of a Privy Councillor. And the oath of a Privy Councillor says, again, I'll read a part of it into Hansard. The councillor says, he will, to his utmost bear faith and allegiance unto the King's majesty, and will assist and defend all jurisdiction, my words now, Jamaica included, preeminences and authorities granted to His Majesty and annexed to the Crown by acts of Parliament or otherwise. And it went on.
Who took that, Mark Golding?
We all know who took that, and I surely know it was not the leader of the opposition, Mark Jefferson
Every Prime
Golding.
Minister of Jamaica has been a member of the Privy Council. Every one of them.
And so,
Not true, not true,
Which one has not been?
not true. We're not going
Mr. President, I am reading the oath that the Privy Councillor takes.
That's Andrew
And
Woods'
if a Prime Minister is so committed and wedded to the sole interest or the interest of Jamaica solely, then this oath ought not to be taken. Mr. President, that is how you show that you're serious about Jamaicanizing the country. Thank you, Mr. President.
Thank you very much, Senator Fraser-Binns. Senator Sapphire Longmore, always a pleasure to see you.
Likewise. Mr. President, I have to rise and make a contribution to this very fundamental bill. You know, we rise in governance to seek to see to the well-being of our people. And I have had many occasions where, as we seek to find the solutions to the ills that exist in our society, we have to recognize our history in that. And so I could not take advantage of this opportunity to recognize this very fundamental step in our history as a part of the solution to some of those ills that we suffer today. Mr. President, I have sat and I've listened to the utterances, and all I can say is I have always had respect for Senator Ransford Braham, and that continues to be so. It is unfortunate that the nature of this bill and the purpose of it is being contrived in ways that seem to be without the best interests of the Jamaican people at heart. We are here seeing the first legislative step in the continuation of the healing of this nation from the significant, very significant post-colonial impact that we are still suffering. I am speaking for myself here now, my colleague. And at the end of the day, as in my opening, I spoke to the many ills that we have connected to that past, as did my colleague in his presentation. Yes, he did. Yes, he did. And so I will also, I know that it has almost become the norm for myself to open with the prayers for this chamber. And I've heard the criticisms to such. I too take great umbrage when I recite those words. But I recognize the purpose of prayer is to sometimes rise above the words for the purpose in which it serves.
And which it was intended.
And for which it was intended. Sometimes you have to be a part of something to change something. And it is indeed unfortunate that the purpose of prayer for the guidance of the good and best effort on our parts to the betterment of the Jamaican people is being contrived in a way that is seeming disloyal to the Jamaican people, when in fact we are here trying to craft our way out of such confusion in our identity. Mr. President, the purpose of this bill, and as I said, I am grateful for Senator Braham for bringing us that awareness as to the approach that is being taken in steps, perhaps also to ensure that we're stepping in the right places at the right time. It is another story if we come with one massive piece of legislation that could be prone to many inaccuracies. And so, Mr. President, sometimes the journey of 1,000 miles begins with the first step. And so I, as I said, had to rise to recognize, if even for those of us who grapple on a daily basis with the consequences of our past, that us in the present are making strides on this day to impact the better future for our Jamaican people. And if this is the start that we have, I press forward and I celebrate it. Thank you, Mr. President.
Thank you, Senator Sapphire, Dr. Sapphire Longmore. Senator Scott Motley.
You know, Mr. President, this morning when I spoke about the former president of the Court of Appeal, it was remiss of me not to thank him for the legacy which he has left as we struggle with our colonial past. Because one of the most significant judgments which he delivered was the one where he said that people who wear hair like me should have the right to do so when attending an educational institution. And Senator Longmore, as you speak about breaking the colonial past, that is one of the things that we have struggled with. Indeed, 25 years ago, when I started wearing my hair in locks, I was warned that I would not be permitted to appear before the judges wearing locks, because that was the environment. Suffice it to say that after a time, a number of the judges who now wear locks discussed the wearing of locks with me and sought my opinion as to who would be the best person to go to have it done. And the irony of it for me has been to see all those women in the court and all those women on the bench wearing locks, and yet a child was prohibited from wearing their hair. And it's always about black styles. It's always about braids, about the knots, and about the locks. And so I, for one, have been very, very clear about the need to break with my colonial past. When I look at the Minister of Health, who now promotes a healthy lifestyle, every time he comes on, I am reminded that some of those problems which we experience are the legacy of our colonial past, because we are still living with slavery in our DNA. And when I look at the complaints which are made about our men say, we get one child, I said, but that's all they were required to do when they were slaves. So we are constantly wrestling. And I, for one, am not only deeply committed to severing our ties with the monarchy, I wish to have it done as quickly as possible. Because every time I think about the monarchy, I think about slavery. For me, it's a natural progression. I don't have anything against any of the royalties. But I can't help but thinking how our women were treated, were raped, were despised, were made to feel like they were just simple property, how their children were taken from them, and how our men, not just studs, Senator Longmore, how they were beaten, how they were abused. And now we ask ourselves, how did we get to this culture of violence? But that is not for today's discussion.
Well, I have no problem with that in my generation.
You know, I want to address simply because, and I am impelled to do so quickly because I know that we have to consider our staff and that they would like a break. So I'm going to go as quickly as I can. Mr. President, when I was appointed to the Constitutional Reform Committee, I was elated. I felt proud, and I looked forward to the experience because I said, I am going to have my name written in history as being one of those persons who finally led Jamaica on the pathway to becoming a republic. As things have progressed, my own hopes have been dashed. Firstly, by the timetable which was laid out by the government, we were constituted in March 2023, and the timeline for laying a bill, for tabling the bill, was May 2023.
Where? May 2023?
And one of the problems that we had with that, with how did the public consultation then emerge? How were we going to get the public's input? And the response was that the 1995 report was going to serve as a basis for determining what we did here now, then in 2023. And the young people said, but I wasn't even born then. You know, just like how me and you know about Gilbert, Mr. President, and some other people don't. So they're saying, what kind of input are we going to have into determining what kind of constitution it is that we want? Because it is the supreme law of the country. And so the public forced the timeline. So that here we are now. And what we have is a Constitutional Reform Committee report. And I want to tell you what that report said about this section which we are debating. The CRC considered that merely stating the people and Parliament of Jamaica without more would not allow for accuracy in the words of the enactment. Accordingly, the CRC recommends that where the bill is one which requires the approval of the people in a referendum, the words of enactment should refer to the Parliament and people. In other cases, the words of enactment would simply refer to the Parliament of Jamaica. This CRC further recommends that effect should be given to this recommendation by the passing of an act prior to the tabling of the bill for the establishment of the reformed constitution. And in making this recommendation, the CRC is aware that the bill for the reformed constitution will have to be presented to the Governor General for assent. This is because the legislative role of the monarch to provide assent for the bill to become law remains unchanged until the reformed constitution is approved in the referendum. So I don't want us to believe that in changing this now, it means that we are liberating ourselves from the requirement that the Governor General will have to, and therein. So when the matter was put to the CRC, and the CRC was notified of this intended change, everybody said, but why would we do that now? So it's not in opposition. Nobody's opposed to it or to the sentiment of it, you know. This was determined from way back, from the 1993 report. This was one of the consensus items. We are simply saying, and I thank you, Senator Braham, for getting up, because I didn't think it was appropriate for me as a member of the committee to say how I felt. But once you got up, you allowed me the freedom. You allowed me the freedom to speak. So, yes, but I am not.
Members, please allow
him.
Senator Scott Marty to complete our presentation. Leader, please. Senator Braham, please.
Respectfully, once he stands, he permits me to stand. He removes my the moral repression which I imposed upon myself and nobody else. Only me, to myself. So when it came to the CRC, as I was saying, people were saying, but why? Why now? Now, would I have suggested a different approach? When you table the bill to become a republic, as Senator Braham eloquently laid out, it has to be tabled in the House of Representatives, so 3 months before it can be debated. That, to me, would now be a more appropriate time to have this amendment made, because then we would be truly on our way to becoming a republic. I am one of those who have stated from the very first time that we sat, when the records, the verbatim records are released, as one day they will be, I hope, my concerns, which I am never hesitant to articulate, were very clear. I said we have some issues that we have to confront immediately. We have to look at the timetable which we are laying out for this referendum. Because the difficulty is that if it comes too close to an election, it means that the opposition and the government will have to be speaking with the same voice. And for me personally, it's not problematic because I have my own strong views. But it has to be taken into account how we will do that. Now let me tell you how this whole matter has evolved, and several matters. The matter of the CCJ is of great significance, and unlike what Senator Abka Fitzhenley says, it has always been a thorny issue. Indeed, it was not until a Vale Royal talk organized by the church when we sat across, the Prime Minister and his team across there, us on this side, the next side, and we were able to speak to each other with civility and discuss some of our concerns. And certain assurances were given that the leader of opposition named 2 members to the CRC and later was asked to nominate another member. It is not a new development. The leader of opposition has always said that he needed to have the CCJ on the table. And I'm going to remind you why. Because in the case which was brought by Arthur Williams and Christopher Tufton against the then leader of opposition, it was said that part of the reason why the device of undated letters of resignations was created was because...
Anybody in here signed those letters?
No, I'm being very serious here. Was because of the concern that somebody might support the CCJ. Because the CCJ, in the nature of the entrenchment, was that at least one opposition person had to support it. Now, trust is a very important thing in political life. It's a very important thing between people, full stop. And the fact of the matter is that some of the members of the People's National Party are saying, so why do you trust them? Will there ever be a phase 2 if they win again? Will they ever support the CCJ if they win? Will they support the CCJ if they lose? Because when they were in opposition and we needed that one opposition senator, everything was done to prevent the free conscience of that senator reigning.
With the greatest of respect, all of us voted our free conscience.
So,
I was one of them.
So,
really?
It never went to a vote.
Never went to a vote. Never went to a vote. The debate was abandoned.
No, it didn't go to a vote.
We debated.
So my call has been very clear. When we go into that room as a committee, there are many of us who compromise on our position to arrive at consensus. Because consensus does not mean that we all agree. It means that we have a common goal, and so we can't have a rigidity and fixity of what it is we desire. And we have, in the beginning of that committee, it worked remarkably well. I have said that you couldn't come in the room and know who represents who or who care about who, because our purpose was to create a new nation, the Republic of Jamaica. Now, one member of the committee made a big deal over the fact that I missed a meeting because that one of the meetings I did not attend. And the record is there, so you can the record is there, so you can see what the attendance was like. One of the members went on a radio interview and flippantly ridiculed the fact that I missed a meeting because it was my husband's birthday. Now let me tell you something.
No, don't tell them. Don't
Okay.
tell them. Don't tell them.
You know, there are some long-standing commitments which people have, and everybody is free to choose whether or not they honor them.
Absolutely.
That day was a special day for us as a family. It has always been. I don't say man get treated that way, but if you can't, as a leader, honor a commitment to your family, how are you going to honor a commitment to the people who you represent and to your nation? That's an aside.
Argument.
When I returned to the meeting of the CRC, there was a clause which said that anybody who appoints somebody to the Senate has the right to remove that senator. And I said, but you can't do that. How are you going to say that the person who appoints a senator can remove a senator? So in other words, if my party said we don't support states of emergency, and I felt as a senator that I wanted to give the government of Jamaica an opportunity to implement its policy, which in its own best interest it thought was a policy which should be implemented then, and I voted with the government, before I leave the precincts of the parliament, I would have lost my job. Yeah. And I pointed out that the very way in which the Senate was conceived and how deeply entrenched clauses, how entrenched clauses were approached, was to preserve the integrity and the independence of the Senate. And once you took away that independence by saying whoever appoints can remove, madness, I thought it was compromise. And I asked the other question, who has got this mandate? Because the public is asking for greater and greater accountability from its leaders. And when you put in a clause like this, what you're doing is that you're turning your backs on really what the public, civic organizations, and what the people are asking for. And you're not watering down, you're removing a pillar of our democracy.
Absolutely.
That's right.
So, I just want to make it clear. There is no opposition to this bill. For me now, it is what the Prime Minister used, a term the Prime Minister used, it is empty symbolism. We don't know when we're going to go to a referendum. I wish we had had it already. But the closer it gets to an election date, when you sit down and you work out the timetable, because the government has now said the bill is going to go to a joint select committee. When you sit and you work out the timetable, Senator Morris, the bill has to be laid and remain on the table for 3 months before it's debated. It is then debated. A bill like this, most people are going to want to speak on it. Look at us today. It then has to, after the debate is closed, it has to remain on the table for another 3 months. It is then sent to the Senate, debated in the Senate, and then returned to the House, where no no less than 2 months. That means it has to be there for 2 months. No more than 6 months, a referendum date is set. Senator Kamina, you think we're going to have that before the election?
Well, if you put on the election for 2 years, you can do it. If you put on the election for 2 years, you can do it.
That's why
So some of the things you know, I don't know if, for example, we would have an appointed day for this bill. I'm not sure how it is being approached. Maybe if you had an appointed day that would be set sometime in the future, I am not sure. I've not thought about that aspect of it. But I would like to give some life and credibility to the process. That's the point I'm making. When will this bill take effect? You know,
That's the question.
my colleagues, Jamaica deserves to realize its fullest potential. And there are some things that don't seem important, because when I go out and I try to explain about it, first of all, there are many people who didn't know that our constitution looked like this. They're seeing it for the first time, which I think is sad. And they ask the question, so what Republic going to do for me? And it's hard to explain. So I will say, you see, like when Shelley win and stand up on the stage, and when you see Bolt, and when you hear that Jamaica has the 3 fastest people in the world, and your heart swells with pride, and everything just feels like you get so emotional and you feel like we are larger than life and all of us are winners, it's that kind of feeling. It's a feeling that you can't really write down how it feels. You just feel it. It's a feeling that you feel. And I just simply say that all of us on both sides have to communicate to the people that this feeling is something that we need to feel. If it pleases you, Mr. President.
Thank you, Senator Scott Motley. Senator Golden, Senator Golden Campbell.
Thank you. Thank you, Mr. President. It really had not... It had not been my intention to make a contribution today, but I felt so moved in the course of listening to my colleagues. And I am, excuse me, I'm still getting over a cold. I'm happy to follow the contribution of Senator Scott Motley, because she touched on something that I think is fundamental, not just to the bill before us today, but also to the entire discussion surrounding the process of constitutional reform, which is not a new discussion. It's been going on for some decades. And that's the question of identity. It's an important issue, and it really is the underlying issue in all of this. Identity. It is implicated in the discussions about the choice of the apex court. It's implicated in the discussions about the oath of allegiance, the question of citizenship, the question of how we structure our government and what we want a reformed constitution to look like. And I relate to these things, Mr. President, by drilling it down to some very basic and simple things. I don't have much expertise in much things,
but I think I have an expertise in my own children. I would not declare any expertise in children generally. And so in my PhD that I have acquired in raising the children that I do have, and I'm blessed to have 2 stepchildren as well, I deal with the issue of identity. I deal with the reality of a child that Jamaicans like to call Browning, and one who looks more like me. And I deal with the reaction that we have, that our mental position arising from our colonial past gives us when people see my girls who have 2 different complexions, though coming from the same mother and father. Why am I sharing that very personal story? I'm sharing that story, Mr. President, because when I was in high school at Immaculate Conception, I remember that pressure on young girls. Skin color was a thing. I met it again in 1990 when I enrolled at Howard University in the United States, and one of the criticisms made of me was that I wore white girl lipstick, pink lipstick. It was the only color I was allowed to wear. My mother thought everything else was too grown up. And I point that out because I then, in the course of time, saw girls, instead of relaxing hair and creaming and conking, I saw braids and then dreadlocks. In my time at Immaculate Conception, I don't think dreadlocks was a thing. I went to orientation there a couple weeks ago, and one of the young fifth formers who was leading the process had dreadlocks. And my daughter was admiring her hair and asking me if she could do hers like that too. Identity. Identity is what we are seeking in this process of constitutional reform. How do we define ourselves as Jamaicans, as the Republic of Jamaica? And that process, Mr. President, is not a straight road. We have been on this journey for some time. In 2006, when I returned to Jamaica, I remember asking the question, but how come if the Labour Party held government for 5 years without an opposition, why didn't we just change the Constitution? We didn't need them. And the answer I got from somebody in a position to have known at the time was that at the time our Prime Minister, Siaga, was very careful about taking the kinds of steps unilaterally that would ordinarily require some consensus and discussion. And he did not feel that that was the appropriate thing to do, notwithstanding the reality of the constitution of the parliament, the membership of the parliament at the time. I find that to be a noble position, or found it to be a noble position, and I accepted it. I accepted it. So we move along and we continue this journey of constitutional reform. And in that process, my colleagues on the other side say it's piecemeal. It is, what was it my Senator Brown said? It's Botoxed. So, Mr. President, I have another story to tell you. Because in 2016, I had the privilege of sitting beside the Right Honorable, the Most Honorable, forgive me, P.J. Patterson, former Prime Minister of Jamaica, during the swearing-in ceremony of our current Prime Minister of Jamaica, Most Honorable Andrew Holness. And Prime Minister Patterson shared with me while we chatted throughout the ceremony that it was he, as Prime Minister Holness was taking his oath of allegiance that day, he pointed out to me, Prime Minister Patterson pointed out to me, that it was he who had pushed for the reformation in the words that constituted the oath of allegiance. And if I can too read that, the oath of allegiance prior to 2002, I, blank, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors according to law, so help me God. And of course, we know our oath of allegiance today to be that I, Shireen Golden Campbell, do swear that I will be faithful and bear true allegiance to Jamaica, that I will uphold and defend the Constitution and the laws of Jamaica, and that I will conscientiously and impartially discharge my duties to the people of Jamaica, so help me God. 2002 was when Prime Minister Patterson changed that. There was no bill on the Parliament floor to effect a change of the apex court. There was no bill on the Parliament floor to do anything of great substance in relation to constitutional reform. So it is striking to me that my colleagues are referring to this bill and the tabling of this bill at this time and taking of the bill as a piecemeal approach. And I'm not taking a very divisive approach to what I'm saying today, because one of the things that I want to loudly, without shouting, say, we are a young nation. We are a nation in evolution. We are not, even by human standards, senior citizens in this business of nationhood yet. It's now 65, Senator Morris. I'm sure you are around for those amendments, right? And even so, 60 years old is young in the realm of nationhood. The fact of the matter is, the work that we have to do to reform our Constitution is not the kind of work that you can necessarily agenda, even in the way our portfolio minister has sought to do so, because there are discussions and debates and considerations along the way that we must give ourselves the room to engage. I didn't know when I was in law school looking at the CCJ versus the Privy Council, writing papers about it for my class in Washington, D.C., that I was going to get to a stage where I was over 50 and standing in the Parliament. And pretty soon, I will too be defunct. My time will be on the way out, and my children and their children will be coming up. And they may have, if we do not complete this work, some work to do, some consultation to have. But I do not think that taking this bill today, looking at changing the words of enactment, notwithstanding that I'm saying we have discussions to have, and that's something we should indulge, is either quick or Botoxed or any of the references Senator Brown made. Why? Because words matter. Words matter. It mattered in 2002 that the Prime Minister was making an oath of allegiance to the people of Jamaica, the parliamentarians were. And if it mattered in 2002, then it equally matters in 2024 that when we get to the position of reforming our constitution through the required processes, that it's the people of Jamaica and the Parliament of Jamaica who will be enacting that law. And so, Mr. President, I'm asking my colleagues on both sides, actually, make we take time with one another. Make we take time with one another. It's one Jamaica we live in. Listen up, Lammy, you talk too much sometimes. We are one nation, and every single one of us here are going to be living under the Constitution that we will create. I thank Minister Malahoo Fort for doing the work to bring this bill to the Parliament. It has done something else that maybe she did not expect, and that is it has engaged my mind, and I'm sure the minds of other Jamaicans, as to exactly what some of the things are that we're going to have to do. Mr. President, I want to enact law in the name of my Parliament and my people. I don't think there's any Jamaican who is going to say otherwise, and I don't hear my opposition colleagues saying otherwise. They have, in fact, said they support it. But in the process of constitutional reform, in the process of coming to the point of tabling a bill to reform our Constitution, let's continue the discussion and let us take time with one another. May it please you, Mr. President.
Well, we start with a lot of excitement, and we have ended with a very sobering note. Minister.
Thank you, Mr. President. Mr. President, no, it's all right. Thank you. Thank you. Appreciated. Mr. President, there are just a few points that I would like to make clear in closing. One is that the bill before us is not one of empty symbolism, feel good, or Botox, nor empty justification of rent payments. This bill is about ensuring that the autonomy of the Jamaican Parliament and the people of Jamaica in the legislative process is secured, and it is secured without delay. I think that the question has been asked, or rather the opposition has asked. They have said they support the principle. The acting leader of opposition business has even read the Constitutional Reform Committee's report on the issue of enacting words. And I want to encourage people who want to have a look at it. It's at pages 15 to 16 of the report. And it expressly states that the CRC recognizes the need for a bill to do what we are doing today, and that this bill will, it said, they address not only the people and Parliament of Jamaica as had been suggested in 93, but that it would go further and ensure that it separates between a referendum and ordinary bills. But essentially, it expressly states, the CRC further recommends the passing of an act prior to the tabling of the bill for the establishment of the Republic of Jamaica to give effect to the recommended new words of enactment. I'm reading from the report. Paragraph 3.65. The CRC further recommends the passing of an act prior to the tabling of the bill for the establishment of the Republic of Jamaica to give effect to the recommended new words of enactment. And it goes further in 3.6.6 to say, in making this recommendation, the CRC is aware that the bill for the reformed constitution will still have to be presented to the Governor-General for assent. And this is because the legislative role of the monarch to provide assent for a bill to become law remains unchanged until the reformed constitution is actually reformed. So two different points, because the first is about timing. It was agreed, or the consensus was, and we recognize consensus is not unanimity. That is settled. But consensus is the point that the group agrees to get behind as a final position. And this is clear that the bill would be done before. And I think no one could have or did do a better job of explaining what was described as a philosophical incongruity. I love the phrase, Senator Braham, in saying that when we are moving to a republic, that the bill that creates the Republic of Jamaica, that it would be enacted by words that say, by His most excellent majesty. It is philosophically incongruent. It is not feel good. It is not basic and emotional. It is not illogical. It makes every form of sense to be less elegant than Senator Braham, but to maybe say it in a way that will be more easily understood. The fact is that it cannot be considered illogical or empty symbolism for it to be the Parliament of Jamaica, the people of Jamaica, that enact the bill which creates the Republic of Jamaica. That is the bill that removes the king as the head of state of Jamaica. It makes every form of sense, and that is why we are standing behind the bill which is with us, before us today. Secondly, I want to just address the point in 3.6.6, and this was the matter of the Governor-General retaining the right of assent. Senator Brown, see, I'm not referring to you at large, Senator Brown. Senator Brown had a deep concern about this. We journeyed to East Africa and the Kenyan protests and the importance of the role, as he found, of President Ruto in refusing to assent to the bills that had been passed by Parliament. He spoke to Governor-General in Australia, refusing to assent to a bill that brought a government to an end. And he asserted that the right of, or the existence of a power of assent was an important part of the process, and he asked expressly that I address this issue because he was concerned if this bill was changing that. This was what you did. This was what you asked. No, you also asked. You asked separately. You asked later in the day where you asked expressly whether the role of the Governor-General in granting assent is still going to be kept in the bill. You want to know that. You said you're unclear coming in, and you're unclear going out, and you are unclear now, and you don't want to be unclear going out. This is what you said, Senator Morris. So you both said it. I think there was another point raised about assent, but it was in another direction, and one which I won't address. The point being that Section 60 is unadjusted. The right of the Governor-General to assent remains. It is not changed by this. Section 61 is, as is captured by the introductory words, the preambular language of this bill. It says expressly, whereas Section 61 of the Constitution of Jamaica specifies the words of enactment for every bill enacted by Parliament. And everything that I have said in my opening and that was said otherwise was about Section 61. Section 60 is not amended by the bill before us today, nor is the right of the Governor General to assent. So I know, Senator Morris, if nothing is clarified for you today, the right of assent remains, Section 60 remains, and the bill before us does not change that. So it is on the record. Not only is it on the record, it is the reality that is actually set out in the bill. So I wanted to make those points absolutely clear. I wanted to also just clarify that where the language of the supremacy of the Constitution has been used, this is in the context of the legislative process. So we really shouldn't try to create confusion in an issue where there doesn't need to be. There's enough legitimate confusion. It is about the legislative process. I also use the term the autonomy of Parliament, again in the legislative process. It is about what we have stated here. I want to also just very clearly make the point that this was in relation to Senator Fraser-Binns. Senator Fraser-Binns, I want to state on the record that the Prime Minister of Jamaica, the Most Honorable Andrew Michael Holness, did not swear an oath. He was appointed to the Privy Council. He attended no ceremony. He did not swear any oath. It may well be that that is something that the Judicial Council swears to. The Prime Minister is not a member of the Judicial Council. So I would suggest a little more research, a little more reading. There are different, I am saying to you, ma'am, and I am saying here for the purposes of Hansard, that while he was appointed, it's a matter of public record, he did not swear an oath. He did not swear an oath. You swore an oath. Of course you swore an oath. We were all sworn in as senators. No, it is not. Well, then you take a different point. You want to say that the Prime Minister is not a member of the Privy Council? Say that. But that's not what your colleague said on the record on her feed. She said he swore an oath, which he has not. He has not sworn an oath. That is my point. It is on the record. It is there for Hansard. I want to make that point clear. I also want to make the point that on the matter of the opposition stating that they are in support of the removal of the monarchy as our head of state, and that this is not a matter that is disputed. I think that is a good thing. The concern is, however, that if you keep adding conditionalities, because the point raised, the quote raised by Senator Fitzhenley, the quote made in April 2022, right here in this Parliament, but not in this chamber, but of course elsewhere. The point was made that we should go forward on the things on which we agree. This is also a point which was made by former Prime Minister Patterson. He's made it in writing, to the Prime Minister, he has made it openly and verbally. Let us move forward on the things on which we agree. It was a concept before going into the CRC. We all agree to removing the king. Now more Jamaicans than ever agree with that position. So now is the time. Why would we want to delay? There are other things on which we don't agree, like the CCJ. But we know that there are points at which I am going to say that there is no reason to delay further on the starting on this process to remove the monarch. And this is said without bitterness. I'm a Minister of Foreign Affairs and Foreign Trade. The UK is an important development partner for us. In fact, before the election even took place, they had reached out to say, we know we have an election coming up. We know, however, Beryl is heading for you. You were working on resources to help you, to stand up resources so that when it hits, because that is the trajectory, we will be able to help you. They are partners, strong development partners. And this is not to say that there is not a regrettable history which is condemned in every way and was condemned by Senator Fitzhenley. You simply stuck on the very first part of his phrase. People understand what he meant and will understand what he meant. But the point being that your addition of conditionalities to the removal of the monarch is what weakens your assertion that you want to get it done. Let us move forward. Let us move forward on the things on which we agree, including the move to a republic by the Jamaicanization of our head of state. Let us do it. We agree on it. Why add any conditionalities to it? Let us debate the other issues. This is the point that I think we need to focus on. So when we question the strength of your assertion, it is because of that addition of conditionalities. It was a day after the report was to be signed, all of a sudden, no, not without. Come on. People, Jamaica people look on. And it is not to say that it might not have been said before, but the position, the most recent position was, let us move forward on the things on which we agree. So in that context, Mr. President, and in the understanding of the importance of us moving forward, not only on the recommendation made by the CRC, but the very clear removal of the philosophical incongruity of us ensuring that when the bill comes to remove the monarch as the head of state and to create the Republic of Jamaica, that bill will be done by the Parliament and people of Jamaica. It will be enacted by the Parliament and people of Jamaica and no one else. I thank you, Mr. President. Might the bill be read a second time?
The question is that the...
Minister said the Prime Minister has not taken the oath.
No, I'm not getting into that one.
But on the 21st of July, 2021, a statement from...
Senator, the question is that the bill be read for a second time. Those in favor? Against? The Senate will now resolve itself. I'm sorry.
A bill entitled An Act to Amend Section 61 of the Constitution of Jamaica to provide for new words of enactment read a second time.
Thank you very much. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. Thank you, members. I put clause 1. Those in favor? Okay.
The Prime Minister of Jamaica denounced the Privy Council oath.
Senator Brown, please. I put clause 1. Those in favor?
No, I'm putting on an amendment.
Senator Brown, I'm not entertaining it.
No, it's...
I put clause 1. Those in favor? I put clause 1. Those in favor? Against? I put clause 2. I'm not entertaining. I'm taking. I put clause 2. Those in favor? Against? I put it. And I'm not entertaining it. I put the title and enacting clause. Those in favor? Against? Ayes have it. The question is that I do report the bill as having passed committee stage without amendment. Those in favor? A vote? No, he's right. What is it? Members will vote on the legislation now, and the vote is to be done. An ordinary majority is required, so that the clerk will read out the names.
Senator Allen, Senator Braham, Senator Bunting, Senator Brown, Senator Crawford, Senator Fitzhenley, Senator Fraser Binns, Senator Gale, Senator Golding Campbell, Senator Hill, Senator Johnson Smith, Senator Dr. Longmore, Senator Professor Morris, Senator Dr. Morris Dixon, Senator Morris, Senator Samuda, Senator Scott Motley, Senator Sinclair, Senator Waby, and Senator Williams. Thank you.
So I have a vote, you know. No,
My apologies.
I
Mr. President.
have a vote.
Mr.
Yes.
President.
I'm instructed by the clerk that the numbers are ayes 15, abstained 1, absent 5. The Constitution requires a majority of the Senate, which would be 11, which would mean 11, and the number is 15. So the bill, I do report as having passed with a majority. Eh? 1 minute. Senators, Minister and Scott Motley, we have to take a break, you know.
Mr. President, may I ask for third reading, but may I also just suggest that as the opposition has indicated that they really will simply approve the regulations and Senator will briefly open to present them, that we wouldn't be prolonged in the second element.
It is not I you are to convince.
But if I could ask staff whether they would indulge us for this, because then it would mean that the afternoon would be free, the afternoon would be clear. Less than half an hour.
Okay, thank you very much. So you ask for a third reading. Oh, ministers asked for a third reading of the relevant bill. Those in favor? Against?
A bill entitled An Act to Amend Section 61 of the Constitution of Jamaica to provide for new words of enactment, read a third time and pass.
Yes, sorry. Minister Dixon. Morris Dixon.
Okay, thank you, Mr. President. I now move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
The question is, as posed by the minister, those in favor? Those against, the ayes have it.
Mr. President, I have to thank the staff for indulging us and allowing us to finish the business of today. And I will go through as quickly as possible. I will do a short and condensed version of this. But Mr. President, before I begin, there is a development that I would like to note today in relation to the global IT outage that we're seeing around the world. We have seen it affect many countries. In some countries, their emergency services are down, planes have been grounded. It is causing significant issues. Some experts have said it is the biggest IT outage that the world has ever seen. So it is a very substantial situation that we are facing today. I would like to note that the Jamaica Cyber Incident Response Team, JISTV, and the Major Organized Crime and Anti-Corruption Agency, MOCA, are actively working with affected entities in Jamaica, both in the public sector and in the private sector, to address this. They're working to mitigate the impact and recover the effects of the global outage affecting Windows-based systems that have the CrowdStrike endpoint detection and response software installed. And we should note that Mac and Linux hosts are not impacted. Also note that this is not a security event or a cyber attack. It is an issue with an update to some software. Preliminary assessments have revealed that 8 public entities have been affected. Several private sector bodies in Jamaica have also been affected, and we're continuing to do our assessments. Most of these are not affected to the point where they can do no work, but some of their systems have been affected. I note this because there are already malicious URLs that are online, set up to trick users who are attempting their own remediation. So in terms of the patches that should be deployed, please ensure that you are using the correct patches for it. And if you're in any doubt, you can reach out to JISTV or MOCA, and they are assisting entities, whether you're private sector or public sector. If you're affected, we will support you in getting you to the right patch to be used. And so, Mr. President, thank you for giving me the time to just note that. In terms of the regulations before us, Mr. President, I'm pleased to open the debate on the data protection disposal of personal data regulations, which were tabled in this Honorable Senate in March 2024. And it's a very short set of regulations. There are more substantial regulations which were already gazetted, but this is the one as per the legislation that has to be debated. And so that's the one that's before us today. The OIC, as you know, has commenced the registration of data controllers under the Act on June 1, 2024, following the end of the 6-month grace period that was granted in January. In keeping with public stakeholder consultations and the strategy of phased implementation of the legislation, the OIC has placed initial focus for the processing of applications on those submitted by data controllers in the priority groups. And we know those were the ministries, departments, and agencies of government, and also businesses that were deemed to be high-risk sectors, such as the financial businesses, health, education, tourism, and ICT service sectors, which process personal data for 10,000 or more data subjects. And so in terms of an update of where we are to date, in excess of 2,580 data controller accounts have been created on the website. And Mr. President, since the commencement of registration on June 1, 2024, for the period to date, 316 institutions have registered on that. And since in our last discussions on the Data Protection Act, I know that my colleagues had said that we needed to do more sensitization, and I'm pleased to note that since the start of this financial year, we have facilitated 13 sensitization sessions with upwards of 1,800 persons participating. And very important to note that these came from 90 organizations, 35 of them in the public sector and 55 from the private sector. The office has also participated in several radio and television interviews on some of the most popular stations that we have in Jamaica, and we've also been on other programming. We've also participated in several other initiatives with the Myers, Fletchers and Gordons, the Jambars Town Hall, and some other private sessions, and including training sessions with the judiciary. So we've been doing quite a bit of work in order to get the message out and to assist those who need assistance in signing up. Given that we are pressed for time, Mr. President, I'll turn my attention to the data protection, disposal of personal data regulations, which have been tabled for affirmative resolution and is now before us today. Now, 3 regulations stand with the Data Protection Act. The first one is the Data Protection Regulations 2024, which was gazetted on March 4, 2024. And the other one is the Data Protection Data Controller Registration Regulations, which was gazetted on April 1, 2024. And before us, we have the third regulation, which is the Data Protection Disposal of Personal Data Regulations 2024. As always, in developing our regulations, we consult. We don't do anything without consultations. We have consulted with Cable and Wireless, Credit Info, Digital Jamaica Limited, the Insurance Association of Jamaica, Jamaica AIDS Support for Life, Jamaica Bankers Association, Jamaica Chamber of Commerce, Jamaica Technology and Digital Alliance, Jamaica Bar Association, the Media Association of Jamaica, and the Press Association of Jamaica, in addition to others. So these regulations here are made pursuant to Section 74 of the Data Protection Act and are intended to secure compliance with the storage limitation standard, which is the 5th standard outlined in Section 28 of the Data Protection Act. This standard provides that personal data processed for any purpose shall not be kept for longer than is necessary for that purpose, and the disposal of personal data by a data controller shall be in accordance with regulations made under Section 74 of the Act. So these regulations therefore provide general guidance to data controllers on the matters to be considered when treating with the retention and disposal of personal data. So it's very limited in terms of what these regulations are trying to do. It's just about when do you get rid of the data, when do you dispose of it, and how do you dispose of it. So in this regard, paragraph 1 of the regulations requires that data controllers regularly review all personal data to ensure that data that is no longer required for certain purposes are disposed of. These purposes include the purpose for which the data was processed, the purpose of enabling access by a data subject to the personal data that was used by the data controller to make a decision in respect to that data subject. So for example, if you did a loan and you sent in information, that would apply there. The purpose of establishing, exercising, or defending a legal claim, or for a legitimate purpose of the data controller. Paragraph 1 of the regulation also requires data controllers to develop policies and implement procedures governing the retention and disposal of personal data. These policies are to specify the maximum and minimum retention periods for which personal data are to be kept. And so we're not saying what it has to be, we are giving flexibility built into it, but noting there has to be a policy that exists. Mr. President, paragraph 2 of Regulation 2 provides that personal data shall be disposed of in a manner that 1, ensures that the data can no longer be further processed or used to identify or be linked to the data subject, and 2, ensure the permanence of the disposal of personal data, taking into account all reasonably foreseeable technological developments, particularly where the personal data concerned is in electronic form. Additionally, the disposal is to be undertaken using any method, process, or technology that the data controller deems appropriate in order to achieve disposal of the personal data. Mr. President, paragraph 3 of the regulation seeks to define the word electronic, and in this regard notes that same has a meaning assigned to it in Section 2 of the Electronic Transaction Act, and that act defines electronic as relating to, I'm quoting, relating to technology having electrical, digital, magnetic, wireless, optical, electromagnetic, or similar capabilities. In conclusion, Mr. President, these regulations are quite important for data subjects and the OIC in its enforcement of the Data Protection Act. And I should note that the data controllers will also derive benefits which may take the form of reduction in the overhead costs related to storage and protection of personal data, to include data storage space, staff, network security measures and devices, and reduction in the risk of security breaches relating to unused personal data. So it's beneficial for all consumers, all members of the Jamaican society, in terms of your data doesn't just sit there for an extended period of time and unnecessarily, but it also helps the data controller to manage its cost and also to limit the pieces of data that it has that could be subject to a security breach. And so, Mr. President, I now commend these regulations to the members of the Senate for consideration and approval. Thank you.
Mr. President.
Senator Fraser-Binns.
Thank you, Mr. President. As our leader stated earlier, the opposition stands in support of these regulations, Minister Dixon. And we're very pleased to have them, because you do know from the last presentation that one of the concerns was how long will information be kept and how will it be disposed of. So we believe that the regulations are timely, and we give our support.
Thank you. Thank you very much, Senator Fraser-Binns.
Mr. President, I now ask that the motion be approved.
Question is that the motion before us be approved. Those in favor? Those against? The ayes have it. Minister.
Mr. President, it is not intended to do any further business today, and I would simply note that we need to consider whether it is that we are able, on the next sitting of the Senate, next Friday, which would be the last Friday before the summer recess, whether we are able to take both of the bills that were tabled here today. We are hopeful that we will be able to, because the income tax is mostly schedules, quite brief, and the road traffic context is actually an issue that has been discussed quite widely. So we are hopeful that that is possible, and that will be facilitated next week, Friday. I'm simply putting House Senate members on notice for consideration of that issue, and taking the opportunity, because I will not be present next week as I will be overseas on government business, to thank staff for all their work, hard work, effort, and their facilitation, including today, before we take the summer recess, and to wish you all a little rest time and a little personal time before they're not always the same when we take back, because it will be an active session when we return. Thank you very much, Mr. President. Might I ask for Senate to be adjourned for a date to be fixed?
Question is that the Senate be adjourned for a date to be fixed. Those in favor? Those against? The ayes have it. The Senate stands adjourned.
Watch the trend, pick up the trend. This are the trend for all the youths them. Watch the trend, pick up the trend. TREND. Big up the trend for education, teachers and the students. A fully bright future, yes, that are the new trend. Better governance, partner with the parents. Follow the big trend, elevate the youth them. Improve the schools, track performance, access and attendance. From infant, primary to university students. Turn up the skills training, full steam we are giving. Follow the big trend, elevate the schools. Yeah. Watch the trend, pick up the trend. This are the trend for all the youths them. Watch the trend, pick up the trend. TREND. For more technology, yes, and better planning, quality education, that's what should be trending. From principals to EOs, everybody winning. Follow the ministry, changing the system. Watch the trend, pick up the trend.
This is Trend, Transforming Education for National Development, a program designed by the Ministry of Education and Youth to transform Jamaica's education system for a brighter tomorrow.
Young Jamaicans up to 35, your government will reserve up to 10% of NHT housing solutions over the next 5 years, just for you, with 100% financing up to 15 million Jamaican dollars. This is how we are empowering and breaking the cycle of poverty meaningfully. Your government is caring for you.
The proceeding was brought to you by the Office of the Prime Minister.
Go down a Manuel Road, Galam boy, to go broke Rockstone, Galam boy. Finger must no cry, Galam boy. Remember the play with the play, Galam boy. One of the story of Big Boy is that Big Boy was in school and teacher Parks, who died for Adam falling race, and Big Boy sat there and teacher direct this question to Big Boy, and Big Boy wouldn't answer. Big Boy's grandmother was behind him with her pin in her hat, and Big Boy wouldn't answer. And when grandmother heard that he wouldn't answer,